For motion, item number 1.
May I please, my lord?
Yes, Mr. Nangami.
Lordship, on the last occasion, that is on dated 26/5/2023,
Yes.
I was asked to receive instruction from the department. Lordship, I have sought the instruction from the Office of the Chief Engineer, PWD, who is the respondent number 2 in the present writ petition, Your Lordship. I'm informed that, Your Lordship, orally, that as far as the termination or the release order is concerned, it is not available on record, Your Lordship. That is what I have been informed, Lordship. Having said that, if I may be allowed to read a para of the writ petition, Your Lordship. Para 9, Your Lordship, page 8.
Yes.
Here, Your Lordship, the petitioner himself has categorically admitted that, I may be allowed to read, Your Lordship. The petitioner states that he became mentally and emotionally shattered and disturbed and fall into the association of bad companies, and he was not in the position to think over his family as a result of mental, psychological disturbance. So, Your Lordship, he did not attend his office at all.
You read the next.
Lordship. However, after the petitioner regained his mental stability, the petitioner started to attend the office for work from November 2018. Thereafter, the petitioner has filed a representation 24/2/2022 to the Executive Engineer PAC Division to consider the petitioner's case and to release the salary. So this relates to the salary only, Your Lordship, as far as the representation that the 24/2022 is concerned.
What about the statement made that he attended the office for work from November 2018?
Lordship, no. Your Lordship, in the impugned letter, which is at page 30, annexure 9, this is the letter which has been replied by the engineer in chief to the legal notice served to the department by the petitioner. Here, Your Lordship, the pictures is very clear. If I may be allowed to read again, Your Lordship. Subject, reply to the legal notice dated 4/11/2022. Dear sir, in reference to your legal notice dated 4/11/2022, submitted on behalf of Sri such and such, the undersigned has perused the service record of your client, and it could be ascertained that he did not attend his duties from December 2001 without any leave or information to the department. The appointment order of your client, dated 29/9/2000, clearly states that the appointment is temporary basis and is liable to be termination with 1 month notice. In the instant case, despite issuing direction and notice to your client by the controlling officer to attend office and holding up his salaries since December 2001, your client chose to ignore the same, and it is clear from the old Indian Service Leave Rules 1995 that an employee absent without authorization for a period exceeding 1 year from the date of expiry of sanctioned leave shall be deemed to have been resigned from service. Now, after a gap of more than 20 years, you are issuing this legal notice to consider your client on the pretext of miscreant threatening him and mental disturbance, which is absurd and unheard of in service jurisprudence. Therefore, it is regretted to inform you that your client such and such case cannot be considered at this stage. So the issue of he going back to the office in 2018 by this letter is very clear, Your Lordship.
The state has also been very casual.
Lordship, that I admit, Your Lordship.
If this was the case, you should have issued termination order.
Yes. Or set up a
You have not issued termination order,
Lordship.
and the petitioner has been able to hang on that
Lordship.
and come before this court.
Lordship. I admit that, Your Lordship. However, Your Lordship, the question is, what right has been violated, Your Lordship? Which right of the petitioner has been violated? We have never stopped him from coming to the office. He himself deliberately did not attend his office for the past 20 years.
Now see, Mr. N. Angami,
Lordship,
without any termination order,
Lordship.
see, this court may not grant any bag wages on the principle of no work, no pay.
Yes, yes,
But when he is not terminated,
Lordship.
maybe that is an issue which you have to really ponder.
Lordship, Lordship, Lordship.
Yes, what is your case?
That is my specific prayer, Lordship. My prayer is very limited, Lordship, and very legitimate, Lordship.
Not legitimate. You are fortunate. You are fortunate to hang on.
Yes,
The
Lordship.
lapses of the government.
That is why page 26, Lordship. Page 26, Lordship. That is a report filed by the respondent number 2 to the respondent number, and respondent number 3 to the respondent number 2, Lordship.
What is
Saying that there was no discontinuity letter from the office of the respondent, Lordship. Now, my lord,
Which letter?
that is at page 26, Lordship.
Page?
Page 26, Annexure 7, Lordship. Second para, Lordship. May I read, Lordship?
Yes.
In this regard, I hereby inform that the incumbent has served intimation letter of absence from duty by the concerned SDO as well as the endorsement by the executive engineer for the same. Copy and close. However, no evidence record such as medical, casual, earned leave as well as service discontinuity were found from the undersigned division. I was because they could have resorted to Rule 9 of the Nagaland Services Disciplinary Appeals Rules, Lordship. But since I was not terminate, Lordship, so my limited prayer is that, Lordship, the period which I was absent, Lordship.
How do you justify you are not going to office for the last 20 years? How do you justify that?
16 years, Lordship.
16 years, okay. How do you justify that?
Lordship, I got lot of threats from the miscreant.
16 years continuous threat?
No, Lordship. No, Lordship. In the year 2002 and 2003, Lordship.
So,
And
on
as a
two
result
occasions.
As a result of which, Lordship, I got mental shock, Lordship, and I have pleaded in para 8 and 9 also, Lordship. And after that, I went for medication. That is the traditional medication, my lord. My lord, I am layman, Lordship. I am not.
Where is your medical certificate?
I do not have because I was undergoing that traditional medication, Lordship, that Ayurvedic, Lordship. Then since I was not terminated, Lordship, I have 12 years more to serve, Lordship. I am not praying that my service should be regularized from the date I was absent. That whatever the period left, Lordship, I may be allowed to continue, my Lordship. I have only left for 12 years, Lordship. And they can regularize my absence as leave without pay, Lordship.
20 years, 16 years,
Leave without pay.
16 years. Had the government issued termination order, we could have dismissed your case at the
True,
threshold.
Lordship. That is true. Right, Lordship. That is my case, Lordship.
You don't have a case, in fact. You have nowhere explained your 16 years of absence from duty.
That is from para 5 to 9, Lordship. 9, my friend has already read out that para 9.
How can you justify your 16 years absence from service? How can you justify that? You may have fallen into bad companies, you may have been mentally imbalanced, but you did not become a lunatic.
My lord, the para 5.
You were a disturbed person, if at all we consider your case. A disturbed person. But being disturbed for the last 16 years,
Please, one prayer, Lord.
Okay, we are issuing notice. Mr. Nangami,
Lordship,
you come well prepared on
Lord,
this issue.
Lordship, Lordship.
You also, next date, you also come prepared to satisfy this court as to why you should be allowed to continue in service.
Sure.
Okay? In spite of your 16 years absence from service. Heard Mr. So-and-so? Learned counsel for the petitioner. Also heard Mr. N. Angami, the learned senior government advocate for the state respondents.
Lordship.
Only state respondents, no other.
No other, Lordship.
No other guidance.
The present petition has been filed for quashing and setting aside the letter dated 13/12/2022, written by the Engineer-in-Chief PWD, Nagaland Kohima, to the counsel of the petitioner. And to allow the petitioner to continue in service of the department till superannuation. Stop. The learned counsel for the petitioner shall serve requisite copies of the writ petition to the learned state council. When?
Tomorrow, Lordship.
Within a period of 3 days from today. Listed after 4 weeks.
Obliged, my Lord.
Yes.
Highly obliged.
For motion, item number 27.
Yes,
The present risk condition is analogous to the measure which was listed today. The mission item of my brother Joshua regarding the compensation.
yes.
Lordship, in the other analogous cases, Lordship, the measure has been fixed on 26th of June. So, Lordship, in the present case also, finally the notice may be issued. In the measure may take along with the other case.
Those analogous cases are for hearing, listed for hearing. There's even you have not issued even the notice to the government,
So, Lordship, I pray that the notice may be issued.
and they may have to file counter. Yes. CGC?
Yes, ma'am.
Heard Mr. Limawabang, learned counsel for the petitioners. Stop. All the petitioners are permanent resident of Akuya village in the district of Mokokchung, Nagaland. Stop. It is the case of the petitioner that the Ministry of Road, Transport and Highways within Brigade Mott floated tender for laning of Longleng dash Tangtungya Road, comma, Mon dash Tamlu dash Merangkong Road, comma, Peg dash Futsoro Road, and Zeneboto dash Chakabama Road under SARDP, all capital SARDP dash NE phase 1, within bracket phase 1 in the state of Nagaland. Phase A, I'm sorry, phase A, within bracket phase A. Stop. The work was allotted to one MS Maitas Gayatri, within bracket JV. JV, stop. For the execution of the work, the MORT, MORTH, was the executing and funding agency, while the PWD Nagaland was the implementing agency. Stop. It is the case of the petitioner that while executing the earthworks, comma, lots of cut earth, comma, stones, comma, trees, etc. were piled up along the work construction site, instead of dumping the same at the identified dumping site. Stop. As a result of which, during the rainy season, the debris slid down on the land and properties of the petitioners, settled along the road, causing severe damages to their land, irrigation and cultivation fields, etc. Stop. The affected landowners accordingly submitted complaints to the state authorities, and the state authorities, taking cognizance of the complaints submitted by the petitioners, requested the Deputy Commissioner of the 6th District to constitute joint verification committee in their respective district to assess and arrive at accurate assessment of damages. Stop. The committee assessed the damages in the presence of the affected individuals in all the 6 districts. Stop. The respondent number 6, thereafter White later dated 26/7/2017, forwarded the damages compensation report to the respondent number 4. However, till date, no payment has been released, and due to which the petitioners are before this court. Since Mr. Zadan Muli, the learned CGC, appears on behalf of respondent number 1, 1, 4, 5, 1, 4, and 5, and Mr. V. Jamomi, the learned government advocate, appears for the respondent number 236
And 7, Your Worship.
and 7. No formal notice need be issued. The learned counsel for the petitioner shall, however, serve requisite copies of the writ petition to the learned CGC as well as the learned state council
Worship, 1 week. It says
within a period of 7 days from today. Listed after 4 weeks. Okay. Yeah, analogous all,
analogous, Your Worship.
except they are from different villages.
From different village in different district.
Your item 2 from which village?
Worship, item 2 is from Mokchung village, from Marangpong village.
From Marangpong village to under Mukokchung district.
Mokchung.
And item 3, 29,
Worship, this is from Kohima district.
Kohima, which village?
Kohima. Chakabama.
Chakabama will be Peg.
Chakabama village.
Chakabama village is Peg.
Worship, in the report, it's given like that.
Chakabama should be Peg. Chakabama Peg. Let us. Okay. The next item 30.
Worship, this is from Longling district. Longling.
Longland district itself.
Yes.
The village.
Village. Urangpong village.
Pardon?
Urangpong,
Orangkong village
under Longling district.
under Longland district. Yes, item 31.
Worship, this is all from Longling,
Village, please.
and the petitioners are from Pura Namsang.
Bura.
Pura Namsang.
B for boy.
Yes, yes.
B for boy. Bura Namsa. NMSA. Under Longland district. Item 32.
Worship, this is also from Longling district.
Village.
Village. Hangjing village, Worship.
Kangching. Kangching village. Okay. Longland, under Longland district. You see the petition. Okay. Yes, 33.
Worship, here the petitioners are from separate villages. They're from Mon district.
Okay, from Mon district. Petitioners from Mon district. Okay. 34. Lema?
33. 34 is other
Oh,
items.
okay. 33, up to 33. Okay.
For motion, item number 34.
Yes, Ms. Kiki.
If I may please, Your Lordship,
Yes,
this current petition has been filed by the petitioner
yes.
because under 226 of the Constitution for the fact that he has been serving as process server under the ABC DenPEC, which is now the principal district session judge of PEC district.
Okay.
And he has been in service for past 13 years now, Your Lordship. And the main concern and the main prayer in this is to grant him scale of pay regarding this current petition, Your Lordship. And how this petition came about to be filed in this honorable court, Your Lordship. Petitioner initially was inducted as service in the year 2009, sometime in the month of 30th of June, 2009, Your Lordship. And if we look at the annexure, which is at A1, Your Lordship, at page number 10 of the writ petition, there it says, page number 10, Your Lordship. It says, in continuation of this department order of even number dated 37/2009, the following casual fixed pay appointments of grade 3 and grade 4 staff in the judicial and prosecution establishment under this department are hereby extended for a further period of 1 year, with effect from 1/7/2010 to 36/2011, as per annexure A attached herewith under the same terms and condition. So, Your Lordship, if we look at this, it's understood that the petitioner was in service since 2009, and his name is also,
Where is his name?
Your Lordship, it's at serial number 9, page number 12. Sri Kurvelu Vero, Your Lordship. So, Your Lordship, in 2009, he was in, his appointment for a process server was given. However,
Where is the first appointment order?
Your Lordship, so in that instant, the first appointment order was being misplaced by the petitioner, Your Lordship. And also, his effort to track the same from the department could not yield any result. In the event of which,
So what is your case? When did he join service?
Your Lordship, technically 2009, but then his appointment order, which was issued at second time as fresh appointment order at Annexure A to Your Lordship. If you look by that, it's at 5th July 2010, Your Lordship. And Your Lordship, regarding this issue, he has also given certain representation to the concerned department, Your Lordship, not just on one occasion, but on two occasions, Your Lordship. The representation letter is at Annexure 4, Your Lordship, of page 18, the writ petition. This was also forwarded to respondent number 2, Your Lordship, who is the Principal Secretary, the Department of Law and Justice, Your Lordship. All his concern is just to give him grant in skill pay, Your Lordship, because currently he is only drawing a salary of 6,930 rupees, Your Lordship. And on top of that, Your Lordship, he has 3 children to look after along with his wife. And that's a bare minimum, Your Lordship, and has caused quite a lot of financial strain to look after his family, Your Lordship. And on the time when he was being his appointment was being first given, he was merely earning a salary of rupees 2,000, Your Lordship. And thereafter which, Your Lordship, 2 representations were given. But till to date, those representation letters have not yielded any results, Your Lordship. Furthermore, Your Lordship,
Where is the other representation? Page
Your
one?
Lordship, the other representation is at page 21, Annexure A5. Your Lordship, if we calculate the time of years that the petitioner has been in service, it's 13 years for now, Your Lordship. Furthermore, Your Lordship, another similarly situated employee in the same establishment, Your Lordship, by the name Mr. Batu, he was given grant in skill pay by the concerned department, Your Lordship, while he was serving for just 11 years and 2 months, Your Lordship. And the extension, the grant in skill pay that has been issued by the government, Your Lordship, responding to in this current petition, has also been annexed in this current petition, Your Lordship, which is at page number 24. This concerned individual was given grant in skill pay on 12th of December 2019 by the department's order, Your Lordship, if I may be allowed to read out, at page 24 of the main petition. In the interest of public service, Sri Batuluro, process server in the office of the District and Session Judge Peck, is hereby granted skill pay for a period of 1 year with effect from 1/12/2019 in the skill pay of so-and-so under ROP 1999 under the following terms and conditions, Your Lordship. So this particular individual in the same establishment was given skill pay, Your Lordship. However, during the time when his skill pay was granted, he was in service for 11 years and 2 months. But currently my position, Your Lordship, I've been serving for 13 years, Your Lordship. And despite 2 representation being served, till today my representation letter have not been considered, Your Lordship. Furthermore, Your Lordship, another similar case was being brought before this honorable court, Your Lordship. And in this particular case, Your Lordship, the court had also directed respondent number 2 to consider similar employees in granting skill pay, Your Lordship. The order has also been annexed in the current petition, Your Lordship, which is at Annexure 7 of page 25, the writ petition, Your Lordship. So this order was issued by this honorable court on 1st of February 2022, Your Lordship. Lordship, if I may be allowed to read the relevant excerpts of the paragraph, Your Lordship. In this case, also similar situation, Lordship, of the previous case that was adjudicated. The concerned individual was serving as an LDA in the at Woka, Your Lordship, drawing a salary of rupees 3,500. He also served a representation to the department. The department did not pay any attention. Thereafter which they came and approached this honorable court, Your Lordship. Thereafter which the court had directed the respondent to consider skill pay paid to similar circumstances employed in the department, Your Lordship. Despite the court order, Your Lordship, which has set a precedent, and despite my representation being sent to the concerned
Yes, who is
department,
for the state? The MS. KKK. Learned counsel for the petitioner. Stop. This petition has been filed. seeking for payment of scale P. Seeking for payment of scale P. Stop. It is the case of the petitioner that he was appointed as a process server on casual fixed pay under the establishment of ADC JPEC, now designated as District and Session Judge PEC, in the year 2009. On a fixed pay of rupees 2,000 per month. The petitioner service has been extended from time to time. The latest being by the order dated 33/20/23, by which the petitioner service was extended with effect from 1/4/2023 to 31/3/2024. The petitioner is currently drawing a fixed salary of rupees 6,930. It is further the case of the petitioner that similarly circumstanced employees are receiving the scale of pay. The petitioner has submitted the representation dated 5/11/2021 and 12 and
24 to 2022.
24/2/2022 to the respondent authorities. However, the same has not evoked any response. Stop. Being aggrieved, the petitioner is before this court. Mr. Vito, the learned government advocate, appears on behalf of respondent number 1 and 2. And therefore, no formal notice need be served to the state respondents. Stop. The learned counsel for the petitioner shall, however, serve requisite copies of the writ petition to the learned government advocate within
course of the day, Your Lordship.
in the course of the day, listed after 4 weeks.
Grateful, Lordship.
For admission, item number 2.
Yes, last time you were allowed 3 days time to seek clarification on the letter dated nil March 2021. Have you received the clarification? Yes. is very difficult to take up case on behalf of the government without proper assistance from government lawyers. Very sad, very sad. This court actually, yes, stand up. This court actually wanted to know what criteria the state government has adopted to pay scale to some fixed pay employees and not to the petitioner. What was the criteria adopted? And the fixed pay, the scale of pay which was paid to the other employees, they are junior to the petitioner. What was the criteria adopted? We'll call your chief engineer. We'll tell him to explain. You read this letter?
Yes,
You read this letter. Read it.
reply to your letter dated 26/5/2023, WPC 303/21. In pursuance to your letter dated 26/5/2023, requesting for necessary instruction for final disposal and clarification with regard to the list of work charge employees who were regularized, which the petitioner received through RTI. The undersigned would like to inform you that all the work charge employees in the list were on scale of pay at the time of their regularization.
That's all.
Yes, Your Lordship.
This court wanted to know how you have classified these employees. Are you understanding my language?
Yes, Your Lordship.
Yes. How the state government has classified these persons who are getting scale of pay, leaving aside the petitioner. On what ground? And this is the reply you are getting for the court. What is this? See, the problem with you is that actually you do not convey the intention of the court to your officers properly. That is the issue, whole issue. Just come leisurely to the court. We wanted to know, this court wanted to know why you are applying different yardstick in paying scale pay to some fixed pay employees and denying that benefit to others like the petitioners. We wanted to know, and you are coming with this letter which says that the undersigned would like to inform you that all the work judge employees in the list were on scale pay at the time of their regularization. What is this? We really feel sorry for the government. The way in which you work for the government is so pathetic. We will have to start giving observation to the government. By the order dated 25/5/2023, the learned senior government advocate was allowed 3 days' time to seek necessary clarification on the letter dated nil March 2021, which was written by the additional chief engineer and PIO additional chief, this is wrong again, additional chief in, there here you have written additional chief secretary, additional chief engineer, okay, and PIO, PHED, Nagaland Kohima. By which information was furnished under the RTI Act 2005 on the list of work charge employees who were regularized under the PHED Nagaland. Stop. Mrs. Lucy, the learned government advocate, has produced the letter dated 29 May 2023, written by the chief engineer, PhD, sanitation and WSSO, Nagaland Kohima, to the learned state council. From the letter dated 29/5/2023, it is not possible to disagree as to what criteria was adopted by the department for paying, scale of pay, and regularizing the service of the fixed pay employees. While denying the benefit, denying the same benefit to other similarly circumstanced fixed pay employees. Stop. The chief engineer, PhD, Nagaland, Kohima, shall take note of the letter dated nil, March 2021, written by the additional chief engineer and PIO Nagaland Kohima to Sri Sinti Younger. And shall furnish proper instructions to the learned government advocate. Clarifying. As to why. The fixed pay employees annexed to the letter dated nil March 2021 were granted scale of pay and even regularized in service, while the same benefit was not extended to the present petitioner. The chief engineer, PhD, shall also take note of the fact that some of the fixed pay employees who were granted scale of pay and subsequently regularized in service were junior to the present petitioner. The learned government advocate shall come with proper instructions from the chief engineer, PhD, on 12/6/2022, failing which the chief engineer, PhD Nagaland, shall appear before this court in person. to explain the clarification as set out in this order. Listed on 12/6/2023.
Lordship, and it is given a copy
A copy of this order may be furnished to the learned government advocate in the course of the day.
Black, Your Lordship.
For admission, item number 3.
Ma'am, is the Lordship.
Yes.
Lordship, on this last occasion, Lordship, by order dated 13/3/23, this honorable court has directed the state respondent to take a necessary instruction as to whether the incumbent Sri Y. Tangsuli Sangtam participated in the DLRP interview, Lordship. And
You
Lordship,
file your affidavit?
Lordship, by order dated 25/4/23, Lordship, Lordship has passed an order to take a necessary instruction as to whether Sri Tangsuli Sangtam, whether he has participated in the DLRB interview, Lordship. And Lordship,
DLRB?
District Level Recruitment Board, Lordship. Lordship, here is a case where the petitioner is challenging the advertisement process, Lordship. The advertisement is of 37 posts of Dubashi grade 2, Lordship.
Okay.
However, one access appointment was inadvertently, given to one Sri Tangsuli Sangtam,
Yes.
Lordship.
Have you cancelled that appointment?
No, Lordship.
Why?
Since Lordship, since they have before the petitioner has challenged before this.
Your, that Mr. Tangse was appointed in excess of the post advertised.
Lordship,
He has
Lordship,
to go. Let him
Lord.
go. That's all, nothing more.
Lordship. So this is the instruction, Lordship. Lordship, I may allow to place this instruction.
Please bring all this by way of affidavit.
Lordship, since on the last occasion by order dated 25/4/23.
16/5/2023. 16/5/2023.
Lordship, and 13, and by order dated 13/3/23 also, Lordship.
Have you filed your affidavit?
No, Lordship.
Then, without filing your
Lordship,
affidavit?
we have filed in the main petition.
Ah.
However, Lordship, this honorable court has directed by order dated 13/3/23, Lordship, to come up with the instruction, Lordship.
This is 16/5/2023. Where is that?
Lordship, in our affidavit in opposition, we have clearly stated, Lordship, that there was an
25/4.
inadvertent, Lordship, on the part of the state government, Lordship. More particularly paragraph 6.
2 weeks' time to enable him to receive instructions. Whether the post in which this Mr. So-and-so was appointed was advertised? How many posts were advertised?
37 posts was,
37 posts were advertised.
Lordship.
How many have you appointed?
38, Lordship.
38.
Lordship.
And this, the last person, Mr. So-and-so is the 38th candidate.
Lordship.
Cancel his appointment. He has no right to stay. He has no
Lord.
right to stay.
Lordship.
We'll give you a week's time. You put that in affidavit, we'll hear it.
Lordship.
Okay? Okay? Yes. Yes.
There is one development, Your Lordship.
What is that?
Respondent number 34.
Huh.
He is already expired.
So what? He was expired.
Yes.
The Mr. So-and-so was actually a wrong entry, an illegal entry.
Yes, yes.
So he has to go, irrespective of whether actually the 38 persons, 37 posts, huh?
37 posts.
Irrespective of whether the one person in the 37 posts expires. The 38 candidate is an illegal entry,
Yes, yes.
so he has to go.
Lordship, out of 37 posts, some of them are in service and some fresh.
Ah,
I am for the 19, Your Lordship. They are in service. They were
no,
DBs.
we are concerned about that, and who is appearing for that 38th candidate? Who is appearing for that 38th candidate? Yes. You are an illegal entrant. You have to go.
Lordship, or else we can dispose of the matter, Lordship, since I have already received the instruction.
So we will hear him also, but we cannot just dispose on the basis of your instructions. We'll hear you. But actually, we want you to actually bring these instructions in the form of an affidavit.
Lordship.
Okay, we'll give you a week's time. Okay. You are challenging the candidature of that 38 candidate.
My lord, in fact, I'm challenging the all 38 persons.
On what ground?
My lord, in my petition, I have also alleged that transparency in the selection process.
You have you participated?
My lord,
Yes.
Yeah, unsuccessful.
And-
candidate. And your
Mr.
lordship,
Yes.
we are already in service, your lordship, and he is a fresh candidate, so he does not have any locus standi to challenge our.
Okay, we'll hear you. We'll hear you.
Yes.
Mr. Vij Momi. Has submitted that he has already received the instructions from the state respondents. Stop. The instructions shall be placed before this court in the form of an affidavit on or before the next date fixed. Listed for admission hearing on, give a date not later than 10 days. Well, listed on 13th.
13, Lordship.
my lord.
Okay.
My lord.
Listed on 13/6/2023. Okay.
For admission, item number 4.
My Your Lordship,
Yes.
I, on behalf of Council for the Petitioner Levels of Your Lordship, the Council is attending a part matter at Court 2, Your Lordship. So
Yes.
I pray that the matter may become after 1 week.
He is attending court.
Court 2, a part of heart matter, Your Lordship, at Court 2.
Okay, what is the matter about? Mr. Lima Obam?
Lordship, here,
We are fixed for admission hearing.
here the petition is challenging my appointment order claiming on the basis of lane ownership.
And you are?
I'm not a lane owner.
How did you enter service?
Lordship, here the challenge in the writ petition is, Lordship, initially I was appointed on the basis of on ad hoc basis. After serving for around 7 years, because a regular vacancy, I was appointed temporarily in that post, in that vacant post. Now the petition is challenging only my subsequent appointment, not my initial appointment.
You are still on temporary basis.
Yes, Lordship. And Lordship, here the ground of the petitioner is, they have a specific statement in the writ petition that you are the landowner and none of your candidate has been appointed. But whereas as per the record annexed by himself in the writ petition, they are referring to earlier proceedings before this lower court. From that record, it is apparent that the writ petitioner's family has been already appointed.
Petitioner's family appointed. Okay, we'll hear you. Where is he?
Your Lordship, the Council is, then maybe come after the listed item, Your Lordship.
Lordship, the listed, the part of it is going from yesterday, report number 3.
Okay.
Timeline.
So we'll list it on
Next week.
6th. 6th, Lima.
It's okay, Lordship, 6.
Listed on 6/6/2023 for admission hearing. It is made clear that there shall be no further adjournment of the case. Kindly tell him that
Yes, Lordship.
he has been informed in advance. So tell him to be here on 6th. Okay.
Lordship.
For admission, item number 5.
May I please, Your Lordship?
Yes.
Lordship, here I am appearing on behalf of MD Apsali, Your Lordship. Your Lordship,
This fellow is not interested to come.
Lordship, you have requested VC, Your Lordship, this morning, but Your Lordship denied, Your Lordship.
Unless you are prevented by some something very important.
Your Lordship, I
Tell
was,
them to come.
Yes, Your Lordship. Your Lordship is from Delhi, Your Lordship, the concern. So I was informed that the client, Your Lordship, is unable to pay the fees.
So what has this got,
For the-
got to do with that?
For the ticket, Your Lordship, since he's requesting for VC, Your Lordship.
Okay.
He is ready.
What
for-
is the client? What is the client?
Your Lordship?
The client is the petitioner.
Yes, Your Lordship.
And what is the petitioner doing?
Lordship, he was discharged from service, Your Lordship, as
Oh.
GT, Your Lordship, and he's unemployed recently.
He has been discharged from service.
Yes, Your Lordship.
He was serving us.
GT, Your Lordship. Lordship, the council is requesting for VC on Thursday, Your Lordship. He is ready to appear, Your Lordship.
In person?
In VC, Your Lordship, through VC.
We have so many efficient lawyers from Nagaland. And this is not a case which is very sensitive or this is a dismissal or termination.
My lord,
Discharge, Your Lordship.
Huh?
discharge.
Discharge
Yes, Your Lordship.
By his own request, my lord.
by his.
Request.
Oh, he was discharged on his own request.
Yes, my lord.
Let us see that. Let us see that.
In my affidavit of opposition, page 11, my lord. And
Page-
it's,
In
One.
affidavit in opposition of all the respondents.
yes, my lord.
Page,
11, annexure 1.
page 11 and extra 1.
That one is MP. Just
Just wait, just wait. This is not understood. So
Yes.
which is the translated?
Translated for this page 12, my lord.
To the commandant officer, 2nd Battalion, for application regarding discharge. I beg to submit for you your kind consideration that I say so and so, but I will not be able to continue my service anymore.
As well, thereafter, we have submitted an affidavit in regard for confirmation of his letter, my lord. That one is the
Oh,
page 13, my lord,
okay.
annexure 3, my lord. According to his own violation, my lord, the authority has discharged them from the service, my lord.
Now suddenly he realized that he has taken a wrong step. We'll give you sufficient time, but no VC.
Lordship.
I want in person.
Lordship,
I want
the
lawyer.
matter can be listed last week of end of June, Your Lordship. Please.
Yes, we'll
No,
give you sufficient time because of the difficulties you have expressed. But let him be here, okay?
Okay,
Okay?
Lordship.
Mr. M. Solo makes a mention on behalf of Mr. Who?
MD Afsal Ansari.
So and so, the learned counsel for the petitioner,
Yes.
and seeks adjournment of the case after 3 weeks. Prayer is allowed, listed on 27,
Lordship.
6/20/23. Okay. Tell him to appear. We're giving sufficient time.
Hello, Lordship.
My lord.
For admission, item number 6.
May I please, Your Lordship,
Yes.
I have filed my affidavit in reply today.
Okay.
Readings are completed.
Pleadings are completed.
Yeah.
What is the matter about, Libby? What is the matter about?
It's regarding with scale of pay, Your Lordship.
Scale of pay.
Yeah,
Your Lordship, it may be fixed for admission hearing after 1
I
year.
find that it is your own creation.
Your Lordship, so
Scale of pay. Anyhow. You are claiming scale of pay to which equivalent post?
Your Lordship, I'm not conversing with the fact.
Who is leading you?
My senior, Mr. L. Likasi Santang.
Okay. It is submitted by the parties that pleadings are completed, and therefore the matter can be taken up for admission hearing. Listed on? We're listed on 19.6, okay? Listed on 19.6, 2023.
For admission, item number 7.
May I please, Your
Item?
Lordship? Number 7.
Yes.
Your Lordship, I'm praying for respondent number 3, Your Lordship.
Okay.
Your Lordship,
Respondent number 3. Who is R3?
Lordship, private respondent, Your Lordship.
Okay.
Lordship, here we won't be filing our affidavit, Your Lordship. The
Just-
matter can be.
Just wait. Who is for the state? Whether state has filed? You have filed your affidavit?
No.
Then?
Lordship, I filed.
You are not even
What-
aware of
what
your
is-
case. That is the worst thing.
Take your apology. Very old case.
Very casual, Mr. Moa. You are a senior government advocate. You are not supposed to be behaving in this manner. So what is your case?
Lordship, is about regularization of service based on seniority list.
Seniority list.
Lordship.
How many years you have served?
Lordship, the petitioner, they've been serving for, all of them were appointed in different year, Lordship.
Okay. So how long have they been serving?
For some for 25 years
Uh,
and 15 years.
You want regularization for what? For pensionary
Lordship,
benefit?
No, Your Lordship.
No,
They
Lordship.
are seeking
Respondent
for
number 3.
regularization, Your Lordship, challenging our regularization order for respondent number 3, Your Lordship.
Who is my junior.
Oh.
So he was regularized before me, so that's why I'm challenging the regularization order of respondent number 3, Lordship.
Lordship, if the matter can come up after 2 weeks, Your Lordship, for admission.
For
hearing.
No, it's all right. I just want to know what is the case about.
Lordship.
And you're also seeking for regularization.
Actually, Lordship, my prayer is that regularization should be given as per the seniority list.
As
Yes,
per the-
yes.
Oh, correct. And you have enclosed the seniority list.
Lordship,
You
Lordship.
have enclosed the seniority list. Okay.
Page 14, Annexure A, Lordship.
Page 14.
Here the petitioner are at serial number 1, 2, 4, 7. Oh, 1, 2, 5, 10, and 12, Lordship. And respondent number 3 is at serial number 4.
Serial number 4.
Respondent number 3, Lordship.
So only 1 and 2.
Lordship,
1
Lordship.
and 2 have the right.
Lordship, Lordship.
You're still on a fixed pay or scale?
Scale pay, Lordship.
Scale pay. And you are scale pay also.
Lordship, I've already been regularized, Your Lordship.
Pardon?
Already been regularized, Your Lordship. Regularized, Your Lordship.
You are regularized.
Yes,
you are
Your Lordship.
scale. Yes. So make way for your seniors. Ultimately, you are a junior. You have to wait for your turn. Yes, is it correct, Mr. Moa?
Your Lordship,
Junior has to make way for the seniors.
Your Lordship, what has happened is that the petitioners, they are contingency, Your Lordship. Contingency employees, Your Lordship. Whereas for me, I was work charge, Your Lordship.
You are?
Work charge, Your Lordship.
So what? These are all fortuitous appointments.
Lordship, if the matter can come after 2 weeks, Your Lordship, for admission hearing, Your Lordship.
Okay, but come prepared.
Lordship.
You are in this case.
Yes, Your Lordship.
Okay, come properly prepared. You just satisfy this court that you can get crush.
Lordship.
Okay. It is submitted by the parties that pleadings are complete. Mr. Moa, pleadings are complete. Okay. It is submitted by the learned counsel for the parties that pleadings are complete, and therefore the matter can be taken up for admission hearing. Listed on. Let us go to the last part of June 26th. Okay, listed on 26/6/2023.
And Lordship, there's an interim.
Okay, the interim order passed earlier shall continue till the next returnable date. Okay,
For admission, item number 8.
item 8. Yes, Mr. MT, pension.
Yes. In your lordship order is 2011, page 22.
2011.
Yes.
What is that?
Page 22.
Page 22.
Yes. Order dated 25/7/2011. 23, date of judgment 25/7/2011.
Before PK Mushahari.
My lord.
Lord. MT Longcha. This is also your case.
My lord.
Your case.
Yes.
So what was the fact of this case? First tell me this case. You are relying on this case.
My lord, what happened is this. One casual employee of the secretary, while going to the office, he died in an accident. Then the wife applied. This is the wife, the earlier proceeding.
Okay.
Then what happened is that she got married.
Okay.
So the two children, the deceased children, are looked after by the uncle.
For how many years did the deceased employee serve the government?
96 to 2008. Yes.
For how many years?
12, see,
For how many years?
12 years. See,
12.
Yes.
12 years. Okay, so actually the wife has come before this court seeking for,
Now the
in this case, 187.
wife is the pro forma respondent in this proceeding.
I didn't get you.
It is the two minor children represented by the uncle.
In the present case?
My lord.
No. I am actually like inquiring about the 2009 case.
My lord. This is yet to be finalized. So what?
This 2009 case is yet to be finalized.
My lord.
For what reason?
My lord, the government side here, they've stated in their affidavit in opposition is para 4 and 11 of their affidavit in opposition. What happened is that we fix the pension in fixed pay. So pension cannot be worked out in fixed pay. That is why he returned it. So after filing this writ petition, we are showing that we are moving the process. That is your affidavit in opposition.
Mr. MT,
My lord.
is this 2009 a continuation of the present petition?
My lord.
Oh.
This is a new writ petition filed in 2021.
Huh. And this is a continuation of the writ petition filed in the year 2009.
My lord.
Why, despite this order, why have you come to this court?
My lord, in spite of a clear instruction from the AG,
Let's see the operative portion of the order dated 2009. This WPC 2009. Let us see the operative portion.
paragraph 7, my lord.
Just wait.
In view of the process submissions
I'm not getting it. Which page?
Page 26 of my writ petition.
Page 26. Yes.
Para 7, in view
Page
of,
26.
yes,
Para 7.
my lord.
Yes.
In view of the opposite submission made by the learned counsel for the parties in as agreed upon to by 10, this writ petition is disposed of by directing the state respondent, particularly respondent number 2 in 3, that is PNAR in Home Department, to finalize the payment of ex gratia to the petitioner as expeditiously as possible within a period of 3 months.
Mr. MP, this is payment of ex gratia.
My lord,
It's not pension.
No, it continues. I have already got the ex gratia. One. The appointed respondent shall also consider in past necessary order in regard to payment of extraordinary pension as per her entitlement in as per the provision under CC's extraordinary pension rules, preferably within a period of 6 months from the date of receipt of.
So what is the stand of the state regarding pension? What is your stand? This in paragraph 7 of the order in WPC 2009, you have complied with one part of the order. You have paid ex gratia. What about the pension?
Your lecture is
Mr. Enangami. Where is Mr. Enangami? Are you taking up this case, Mr. S. Chang? You assist Mr. Enangami. Okay. This is something very critical. Yes, Mr. Nangami. I find that you will be the right government advocate to assist this court. You can take time also, but in the year 2009,
Lordship.
a writ petition was disposed.
Lordship.
In that writ petition, which was of the year 2009,
Lordship.
was disposed in the year 2011. And there were two directions: to pay ex gratia payment to the petitioner.
Yes, madam.
Okay, para 26, page 26. Okay,
Yes, madam.
and also to consider payment of extraordinary pension.
Lordship.
The ex gratia payment has been made.
Lordship.
Now, I think there is something wrong with the payment of extraordinary pension. And that is why the petitioner is before this court. Why your pension was not paid, Mr. MT? Why your pension was not paid? On what ground?
The department, the assessed the pension in the lease through the ET returning to the home department to work out
Okay,
on
okay.
the scale of pay. But
Now, what is the stand of the government?
the stand of the government is clearly given in their affidavit in opposition.
Please read.
Page para 11, my lord.
Yes, what it says? Yes, yes, please.
That with regard to the statement made in paragraph 12 of the writ petition, the answering opponent begs to state the measure was taken up with the DNAR regarding the AG letter dated 2000, way back 2012, with regard to declaration of the service of such and such. The department recommended for posthumous declaration purely for pension benefits
Okay.
The case, the vacancy caused by one gentleman, Mr. Lotha, who retired with effect from 31/3/2020, and it was duly accepted by BNER dated 12/7/2021.
Okay.
The matter is now under process for the cabinet approval as per the recommendation for the settlement of
Oh.
BOP of late such and such.
Okay.
So BNER have already,
Yes, so the matter is now pending before the cabinet.
my lord,
So, Mr. Nangami, I think we will have to see the daylight.
Lordship, as far as the extraordinary pension is concerned, just recently, this honorable court has disposed of the matter with regard to the same issue. Now, Your Lordship, actually, the extraordinary pension rules 1939, that is the CCS Extraordinary Pension Rule 1939, is not adopted by the state of Nagaland. And therefore, that particular rule is actually not applicable. Now,
Whether actually there is some notification from the government stating that provision of CCS pension rule is not applicable.
yes, Your Lordship, in fact, in our affidavit in reply, as well as this honorable court has already taken the stand of the state government that that particular extraordinary civil extraordinary pension rules 1939 is not applicable. Your Lordship, however, having said that, the extraordinary pension in the state of Nagaland is actually governed by an office memorandum that is 6/6/1995.
Okay.
As far as my knowledge goes, Your Lordship.
Okay.
Now, Your Lordship, that particular office memorandum pertains to a regular government employees who who were killed in action or encounter.
That 1995 notification allows payment of extra.
Yes. So under that 6/6/1995 office memorandum, extraordinary pension is permissible. However, there is a criteria, Your Lordship.
Okay, Mr. Nangami.
Lordship.
See, here is a case. Here is a case where actually the petitioner,
Lordship.
irrespective of whether the entitlement is there or not,
Yes.
the petitioner case has been forwarded. Initially, it was forwarded to the AG,
Lordship.
but the AG has returned the pension papers of the petitioner saying that actually the person on a fixed pay is not eligible for pension.
Lordship.
And that is how, after that, the government has actually given posthumous regularization
Lordship.
to the petitioner.
Lordship.
And the matter has been processed before the PNER. PNER has accepted, and PNER has pushed up the matter to the cabinet.
For necessary approval. Your Lordship.
Yes. So
Lordship.
now the matter is with the cabinet. When was the matter pushed up before the cabinet, Mr. MT?
Your Honor, at page
Ah.
16,
When was it dated?
12/7/2021.
12/7. So I think high time. At least you get some information on that,
Lordship.
Mr. Nangami.
Lordship.
Okay.
Annexure 16.
You got it?
Lordship. Lordship, here, if I may be allowed to, Your Lordship, here, I think it is just stated that it has been subject to the approval of the cabinet.
That's why subject
It
to
has
the
not
appro-
been placed. Your Lordship, I will ascertain whether it has
You'll
been
get
placed before the
information,
cabinet or
okay?
not, Your Lordship.
Okay. Mr. Nangami, the learned senior government advocate, and Miss S. Chung for the state respondents. Stop. Mr. Nangami was requested by Mr. Nangami, the senior government advocate, was requested by this court to lead the case for the state respondents. Stop. Mr. Nangami accordingly seeks for 2 weeks' time to get necessary instructions on the case from the state respondents. Prayer is allowed. listed after 2 weeks.
Lordship.
Can we get the information?
Lordship,
Okay.
Lordship. Deeply obliged, my lord.
Excuse me for 2 minutes.
For admission,
Yes.
item number 9.
Yes, ma'am, what is this? What is the matter about?
Your Lordship, on 23rd, 2023, Your Lordship, I was instructed to bring one letter, Your Lordship. Office memorandum, Your Lordship.
Okay, let's. Yes. Madam, what is your case?
Your Lordship, the present petitioner is the second wife of Leptige Gopalan, Your Lordship.
Second wife.
Yes, Your Lordship.
Okay.
And Your Lordship, the petitioner's husband he was earlier serving as supervisor police radio organization, Your Lordship, which fact is established by the order dated November 1977, Your Lordship. I have annexed it as annexure 1 in page number 27, Your Lordship.
That this is government employee also had a first wife
Yes, Your Lordship.
who expired.
Yes, Your Lordship.
In the pension book, who is the nominee?
His first wife, Your Lordship.
First wife.
Yes, Your Lordship.
Yes.
Yes, Your Lordship. Before his appointment as supervisor, police radio organization, Your Lordship, the petitioner's husband, he was serving in the Corps of Signals, Ministry of Home Affairs, Your Lordship. And he was also receiving pension out of that service, Your Lordship. And it was mutually agreed between the two wives that the first wife, she will receive pension from his service as Corps of Signals, Your Lordship, Ministry of Home Affairs, and the present petitioner, she will receive pension from the service benefits of her husband as supervisor, Your Lordship.
Is it possible for a person to enjoy two pensions?
Your Lordship, I believe so.
Don't believe. Give me the law.
Your Lordship, then I may be given some time to ascertain, Your Lordship.
Whether a person is eligible, yes, Mr. MS Inaholi.
Your Lordship,
Whether a person is eligible to enjoy two pensions.
Your Lordship, if it's under the same state government, that it's not permissible. But
If it is under different government.
yes, I don't know about that, Your Lordship. But as far as a same state, Your Lordship, it's not eligible, Your Lordship. And moreover, here, Your Lordship, the petitioner, their prayer is for family pension, Your Lordship. And in order to get family pension, the petitioner name is not in the nominee, Your Lordship.
That is the issue.
Yes, Your Lordship.
But
So-
actually, why she is coming before this court is that actually there is a mutual agreement between the two wives.
But there's no agreement to that, Your Lordship. It's just a mere statement, Your Lordship. No documents to prove, Your Lordship. And now the first wife and the
first wife is still alive.
No, she has expired, Your Lordship.
and there's no document to prove also, Your Lordship.
It was an
Just a
oral
statement.
agreement, Your Lordship.
Oral agreement
Yes, Your Lordship.
to enjoy pension.
No, it,
How is
between
it
the two
possible?
wives, Your Lordship.
But madam, you see, your name is not there in the pension book.
Yes, Your
You are
Lordship.
not the nominee.
Yes, Your Lordship.
So what this court is to do with your petition? What is your prayer? Let's see. What is your prayer?
Page number 25.
Page, you know, the. To show causes to avoid family pension and pensionary when the raising of the services. Simple as this. Your prayer is very simple, but it is very complicated to decide your case. Yes.
Your Lordship, after her husband expired, Your Lordship, she has accordingly applied for succession certificate, and then she has obtained succession certificate, and she was receiving pension for a few months, Your Lordship. However, she lost her copy of the PPO book, Your Lordship, and has been unable to obtain the same till date, Your Lordship.
So in the pension book, your name has replaced the first wife.
No, Your Lordship. It was only after the Office of the Accountant General, the respondent number 5, after they filed their affidavit, Your Lordship.
An affidavit? What affidavit was filed? What is your affidavit, ma'am?
Please, Lordship. Lordship, in our affidavit, we have stated that the only PPO book which we have with us is in that the nominee is the first wife. And regarding the succession certificate on para 5, we have stated that that in respect of the statement made at para 6, the answering deponent begs to state that succession certificate claimed to have been submitted to the office of the deponent is not found in record, nor is there any file noting in support. So the succession certificate which they are claiming is not in with the accountant general.
So, Your Lordship, my humble submission is that it was only after they have filed their affidavit, Your Lordship, I got the information that my name has not been nominated in the pension book, Your Lordship.
No, you are not a
Your Lordship.
nominee,
Yes, Your
so
Lordship.
your name will not be nominated.
Yes, Your Lordship. So I was able to ascertain only after the respondent number 5 has filed their affidavit, Your Lordship. And so, Your Lordship, my humble prayer is that I may be allowed to approach the Deputy Commissioner, Your Lordship, as per the office memorandum dated 13 July 2015, Your Lordship, which I have placed before Your Lordship on the last occasion. And with regard to this office memorandum, Your Lordship,
Which is your, which page?
No, Your Lordship, I have not annexed it in my writ petition, Your Lordship.
Then, who is the next? You are actually making a submission that you may be allowed to approach the Deputy Commissioner.
Yes, Your
As per
Lordship.
the memorandum so and so. Where is that memorandum?
Your Lordship, I have placed that office memorandum on the last occasion when this matter was listed.
Office memorandum dated.
13 July 2015.
Okay.
Your Lordship, when the writ petition was filed, the present council was not aware of the existence of this office memorandum, Your Lordship.
Yes.
Yes, Your Lordship, my humble prayer is that I may be allowed to approach the Deputy Commissioner, Your Lordship, so that if the Deputy Commissioner finds my case to be genuine, Your Lordship, then accordingly pension process may be proceeded, Your Lordship. Lordship, what has happened is that on several occasions, Your Lordship, the petitioner has filed an RTI before the PHQ, that is the parent department of her husband, and the Office of the Accountant General, as well as the Treasury Office, Your Lordship. She has written on several occasions to them, Your Lordship. However, she was unable to obtain her service book, the service records of her husband, even from the Accountant General Office as well as from the Office of the PHQ.
Where is the service book of your husband?
Your Lordship, for that it is not available with the petitioner, Your Lordship. So in order to obtain it from the department, Your Lordship.
Normally, who has the custody?
Your Lordship, normally the state heads, but after the pension matter is settled, Your Lordship, it is with the AG, Your Lordship. The husband's pension was settled. He was receiving pension. So all the service books, it's in the custody of the AG, Your Lordship.
Yes, you are the culprit. Where is the pension papers of the petitioner?
Lordship, the only document available on record is this PPO regarding the petitioner's late husband. The only document we have is this PPO of the late husband.
The pension papers were processed by the state government and it was sent to your office. That is the stand of the state government. So obviously it is you who should have actually the possession of the pension papers. If you have lost, you have to trace them. Because even if we allow the deputy commissioner to conduct an inquiry, without the pension papers, everything will be futile. Is it not correct? Even if we allow deputy commissioner to conduct an inquiry, and the deputy commissioner comes to a finding that you are the legally wedded wife of the deceased government servant, and therefore you are entitled to pension. Even if the deputy commissioner comes to that finding, if your pension papers are lost, what happens then?
Your Lordship, I believe the service book is available with the Accountant General because in their affidavit.
They said nothing.
Your Lordship, in their affidavit, in opposition, they have annexed it, Your Lordship.
Let's see the affidavit. Which affidavit? Affidavit in opposition, okay.
Respondent
Page number
number 5.
6, Your Lordship.
Page number?
Page number 6, Annexure A.
Okay. This is not the service book.
Yes, Your Lordship.
What is this? This is audit register. Is it?
Yes, Your Lordship.
There is not a service book. Where is your service? Where is the service book of the petitioner? Yes, learned government advocate.
Yes, Lordship.
Where is our service book?
Your Lordship, if you may turn to page number 56 of the writ petition, Your Lordship. This is a reply given by the state respondents.
56.
Yes, Your Lordship. This is a reply given by the state respondents to the legal notice served by the petitioner, Your Lordship,
Okay.
at para 7, Your Lordship. It is to state that service books of all retired employees along with pension papers are dispatched to AG Nagaland Kohima for their retirement benefits. Once the pension papers of any retired personnel is finalized by the Accountant General Nagaland, the department is de-linked and any grievances or complaint in regard to pension matters have to be taken up with the AG Nagaland Kohima, Your Lordship.
Yes, ma'am. You seems to be the culprit. Where is the book?
My lord, uh, on the last order, on the last occasion, I have submitted a document.
What is that document? What is that document? The letter?
Yes, a letter. This is with,
Letter dated 15/5/2023.
yes, Lordship. In the first para, if I may read.
Yes.
Late T.K. Gopalan, retired supervisor, police with your organization, Mokokyun, retired on 27/11/1977, and pension was settled by this office by PPO number 983, Xerox, which we have enclosed in our affidavit in Opo. As per this office report, as received from the concerned department, the wife and nominee of the late T.K. Gopalan is recorded as BK Debut. The name of the petitioner as well as her daughter has never been recorded nor furnished to this office as the nominee of late T.K. Gopalan at the time of authorization of pension. So, Lordship,
Yes, but read down, read down. So it means that the service books are with you. Is it?
my Lord, I believe so.
No, don't believe. Don't believe. Give a definite statement.
Yes, if Lordship, I have to inquiry that the PPO book is with us, but regarding the service book, I have to.
Because
make
as per
further
the
inquiry.
state government has actually says that once a pension is finalized, all the service book of that person concerned is sent to AG.
Yes, Lordship.
So if that is the procedure, I don't know, but if that is the procedure, then the pension papers, all the service books, pension papers, everything should be with you.
Yes, Lordship. For that, I have to make further inquiry.
Madam, I think at this juncture, even giving a direction to the deputy director to cause an inquiry may not be very effective unless all your pension books, everything, service books are clearly traced. Because once actually that direction on inquiry, if any finding is given by the deputy commissioner that you are the legitimate wife and you are entitled to pension, then in that case, all the pension book as well as the service book has to be corrected by putting your name as the nominee.
Yes, Lord.
Correct? So when can you furnish this information?
Lordship, can you grant me 2 weeks?
2 weeks just to get that information. You take 1 week.
Yes, Lordship.
Okay.
Yes, Lordship.
Your Lordship, may kindly turn to page number 44. In my writ petition, Your Lordship, this is the letter written by the Office of the Accountant General, saying that the office does not have the record books of the petitioner, Your Lordship.
Does not have the
service records, Your Lordship, of those employees who have retired prior to 2003 to 2004, Your Lordship, as per this office letter written by the Office of the Accountant General. May I read it, Your Lordship? In inviting reference to your letter number so-and-so dated 7/10/2015, I am to inform you that this office does not retain the service books of retired persons whose case were settled prior to 2003 to 2004. As per this office record, Shri T.K.
You
Gopalan-
retired when?
1977. Yes, sir. Shri T.K. Gopalan, retired supervisor, was retired in 1977 and the pension case was settled in 1982. Hence, you are requested to approach the parent department accordingly, Your Lordship.
See, that is
So after receiving this letter, Your Lordship, by the AG office, Your Lordship, the petitioner again made an RTI to the office of, to the PHQ, Your Lordship, and the same was accordingly replied, Your Lordship. On 28 March 2016, Your Lordship.
What was that?
So may I read it?
Yes.
In inviting a reference to your letter number dated 9/2/2016, I am to state that no records of T.K. Gopalan, Supervisor, Police Radio Mokchun, could be traced. It is to state that the service books of all retired employees along with pension papers are dispatched to AG, Nagaland, Kohima, for their retirement benefits. Once the pension paper of any retired personnel is finalized by the Accountant General, Nagaland, Kohima, the department is dealing with any grievances or complaint in regard to pension matters have to be taken up with the AG Nagaland, Kohima. So, Your Lordship, as per the available records, it appears that the state respondents, they are shifting responsibility to one after another, Your Lordship.
You reconstruct. We'll give a direction to reconstruct the service book of the petitioner.
Your Lordship here, but the main issue is nominee, Your Lordship. During his
That is why you reconstruct. After reconstruction, then we follow this OM. We follow this OM. 13 July 2015. We follow this. You reconstruct the service book of this petitioner's husband. You are actually throwing the blame on one another, and you are not able to give any concrete answer to this court's query.
Your Lordship, even the petitioner is also, Your Lordship, defective because they're saying that it's incomplete, Your Lordship, the documents, Your Lordship. The appointment order of the petitioner's deceased husband is also not enclosed here, Your Lordship, which is very crucial, Your Lordship, for this matter. And then even the petitioner does not have all the documents, Your Lordship. Then
How
is the
can
state
you expect
supposed
the petitioner to keep all the service record of her late husband?
But
Is
appointment
there a
order,
submission to
Your
be
Lordship,
made?
Your Lordship.
It is the department which should retain all the records, not the petitioner. Just because the petitioner is unable to produce one or two documents,
Yes,
you
Your
cannot take undue advantage of
It's
that.
true, Your Lordship, but since this is a settled pension matter, Your Lordship.
It is to settle a pension, not settled pension matter. It is to settle a pension
But this is
and
a
to see whether the petitioner is entitled to pension or not.
family pension.
But in the absence of service book, which the department is supposed to keep, and if you are throwing the blame at each other now and making it difficult for this court to come to a conclusion, this court can only direct you to reconstruct the service book. That is the only option left. Which was the page you were referring? And you were referring, please?
Page number 48.
Of?
Annexure 15, my writ petition, Your Lordship. The RTR reply made by the office of the PHQ.
Page number?
48.
Yes, and where is the AG's letter? Where is that AG's letter?
Page number 44, annexure
Which?
11.
Page number 44.
Annexure 11.
And which was the letter you were reading?
Later dated 15/5/2002.
Is it a part of your annexure or
No,
it's in a
Lordship.
loose sheet?
It's in a loose sheet.
Now, where is the pension book?
Your Lordship, the petitioner shares laws with Your Lordship.
Where is the pension book? In whose custody?
For that, Your Lordship, I'm not aware. Because on several occasions I've written.
You have the custody of the pension book?
Lordship, the PPO book which I have is this one.
Kindly tell Mr. Joshua to come properly instructed on the next date, okay?
Yes, Lordship.
Heard MS so-and-so, learned counsel for the petitioner. MS so-and-so. The learned state counsel for the respondent number 1, 2, 3, and 4. Who is for 6? Treasury
I'm representing.
and 6. And MS so-and-so. On behalf of Mr. Joshua Shakti, the learned counsel for the respondent number 5. On the next date, the learned counsel for the state respondents, as well as the learned counsel for the respondent number 5, shall come properly instructed as to which of these two authorities have the custody of the service book as well as the pension papers of the petitioners. Stop. This information becomes highly essential in order to dispose the present petitioner in order to dispose the present petition which relates to the issue as to whether the petitioner, who is the second wife of the deceased government employee, is entitled to receive the pension benefits of the late government employee, who is also said to be the husband of the present petitioner. Kindly bring proper instructions. Okay, you tell Mr. Joshua. Okay, and Inaholi, you please see that actually all these things are properly, like you furnish proper instructions. You cannot just go on like this casually. When do we have it? Give a date.
Worship after 1 week.
Stop. The instruction sought for shall be a written instruction. Listed on 12/6/2023. Okay. Next time, kindly come well informed, at least proper instructions, so that this court can pass order, either directing whichever party, more particularly the state respondents, to reconstruct the service book. Okay.
Deeply obliged.
For admission, item number 10.
May I please, Lordship?
Yes.
My lord, I may be allowed another week's time to file my affidavit in reply to the affidavit filed by the respondents.
Mr. Takakichu, the learned counsel for the petitioner, submits that he may be allowed a week's time to file affidavit in reply to the affidavit in opposition filed by the respondents. Prayer is allowed, listed after a week on a date to be fixed by the registry.
For admission, item number 11.
Yeah, please, Your Lordship.
Yes.
Your Lordship, 3 weeks may be granted for filing counter, Your Lordship.
Okay, MS Lipika, the learned government advocate, 6 for 3 weeks' time to file affidavit in opposition on behalf of the state respondents. Prayer is allowed, listed accordingly.
Much obliged.
For admission, item number 12.
May I please, Your Lordship?
Yes, please.
Your Lordship, my seniors in disposal, let the matter become up after 3 weeks, Your Lordship.
And who is your senior?
Estamjan.
Estamjan. Mr. So-and-so submits that his senior, Mr. Estamjan, the learned counsel for the petitioner, is indisposed and therefore 6 for 3 weeks' time. Prayer is allowed, listed after 3 weeks.
For admission, item number 13 to 19.
Yes.
My blessed Lordship, I have received the counter filed by the state respondents in WBC 130 of 2022. That is item number 13, Your Lordship.
Huh.
So I pray that the matter may become up.
What about the other items? Is it, it covers the others?
In 14, I'm appearing, Your Lordship. I'm yet to file counter.
Who is 13?
Your Lordship,
What is the matter about?
Your Lordship, petitioners are seeking for minimum scale pay.
Pardon?
Scale pay, Your Lordship.
Scale pay. Will your affidavit not cover the others?
Your Lordship, I do not know what the matter is with regard to the other.
What is the matter?
Mine also, Your Lordship, minimum scale pay. They're seeking minimum scale pay, Your Lordship.
Your Lordship, after all, there is only one stand by the state government that there is no particular scheme for granting scale of pay, Your Lordship.
Please tell your government to come up with some other better ideas, not that. That scheme, that scheme is actually of no use.
Lordship, in this case, Lordship, I pray that item number 13 may become up on 15th of June, and then the other items, item number 14 to 18, Your Lordship, it will become up.
19.
Yes, 19, I'm not the petitioner, Your Lordship.
Who is the petitioner 19? Chali. Who is Mrs. Chali Santam?
Your Lordship, no, item
117, okay.
18 and 19 is different, Your Lordship.
Okay, okay, I'm sorry. Up to item
17 only.
17.
So I pray that 14 and 17 will become up.
14 to 17. Who, in only you have a 14 to 17?
I'm only for 14, Your Lordship. I'm appearing only in 14.
Okay, and what about 15, 16,
I'm
17?
for 15, 16, 17.
15, 16. Have you filed your affidavit?
No, Lordship.
Why?
Your Lordship, sometime may be granted, Your Lordship, to file, Your Lordship.
You have filed your affidavit. You filed your affidavit. When can we have it? Item 13?
On 15, Your Lordship, if the opposite counsel is convenient with the date.
What is 15? No, not 15. You can have it on 19 or 20.
Your Lordship, then 19, Your Lordship.
On the prayer of the learned counsel for the parties, WPC 130/22, 2022 is segregated from the other writ petitions and listed for admission hearing on
20, Your Lordship.
26/2023. With regard to WPC 130/2022, WPC 131/2022, WPC 182/2022, WPC 183/2022, and WPC 184/2022, the learned government advocate seeks for 3 weeks' time to file counter affidavit. Prayer is allowed, listed after 3 weeks. Okay? Segregate WPC 130/2022, detach WPC 130/2022 from the rest of the writ petitions. Okay.
Obliged, Lordship.
For admission, item number 20.
Yes, Mr. Nangami.
May I please, Your Lordship? I pray 3 weeks' time may be granted to file affidavit in reply.
We have filed affidavit
Lordship, yes, in both the matters, Your Lordship.
in both means
18 and 19.
19. Mr. Nangami, the learned senior government advocate, submits that in both WPC 136/2022 and WPC 137/2022, the state respondents have filed their affidavit. Stop. Mr. So-and-so, learned counsel for the petitioner, seeks for 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Prayer is allowed, listed accordingly.
Obliged, my lord.
Yes.
Item number 20 for admission.
Your Lordship,
Yes, please.
I pray 3 weeks' time may be granted. to
20.
file it.
20.
Yeah.
You're for the
I'm for the petitioner.
petitioner. You want to file affidavit reply
Yeah.
to the affidavit in opposition filed by the state respondents.
Yes, Your Lordship.
Okay. Mr. So-and-so, the learned counsel for the petitioner seeks for 3 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Prayer is allowed, listed after 3 weeks. Okay.
For admission, item number 21.
Same prayer, Your
Same
Lordship.
prayer, same prayer, same prayer. Oh, sorry. Same.
For admission, item number 22.
Your Lordship, I may be allowed 2 weeks' time to file my affidavit in reply.
To the affidavit in opposition filed by state.
Private respondent as well as the state, Your
Okay.
Lordship.
Mr. So-and-so, the learned counsel for the petitioner submits that he may be allowed 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents as well as the private respondents. Where is allowed, listed after 2 weeks.
Much obliged.
For admission, item number 23.
No? May I please, Your Lordship?
Yes.
My Lord, I prepared the counter affidavit and I sent it for awaiting my Lord, so that the latest matter will come up after 3 weeks.
Are you sure?
Yes, my Lord. A draft copy of affidavit of persons sent for waiting the
You have for respondent number?
One.
Respondent 1. And Lima?
Lordship, I'm for 4 and 5.
4 and 5. Okay. And Inauli for 2 and 3.
2 and 3.
Will it be necessary for the state to file an affidavit?
It's still already filed.
Huh?
Already filed.
Oh, state has filed?
Yes.
And what about you?
I filed.
Filed.
You have also filed? So you're the last bus?
Yes, my Lord.
Okay. Mr. Zaidan Mule, the learned CGC, submits that the affidavit on behalf of the respondent number 1 has been sent for waiting and is awaited, and therefore 6 for 3 weeks' time. Prayer is allowed, listed after 3 weeks.
My Lord.
Obliged.
For admission, item number 24.
Please, Your Lordship,
Yes.
I received the counter filed by the state respondents this morning, Your Lordship.
Okay.
So 3 weeks' time may be granted to file reply.
Mr. Subhamwadi, the learned counsel for the petitioner, submits that he has received the counter filed by the state respondents only this morning, and therefore he may be allowed to file affidavit in reply if so advised, listed after 3 weeks.
Obliged.
For hearing, item number 25 and 26.
Who is for the state respondents?
May it please, Lordship. What the matters are analogous, Lordship.
What is the matter?
Lordship, the petitioners here in both the read petitions, they have served the department for 35 years and 26 years respectively. They were released from service, Lordship. Now this petition has been filed seeking regularization for pension and pensionary benefits, Lordship. I'll be relying on the decision of the Honorable Apex Court, Lordship, wherein in a similar case, Lordship,
In Gujarat's case?
Dalsibai's Lordship, yes.
Dalsibai.
Yes, Lordship. The one-page
Uh-huh.
judgment, Lordship. So in that case, the petitioner had served for 30 years and he was meant to go empty-handed, Lordship.
Correct, correct.
Now, in this case, the first read petition I have served for 35 years, Lordship. During my active service, I have approached the Department for Regularization on 2 occasions, and even after my retirement, I have approached
You
the
are
department.
on a scale.
Lordship, yes, I'm on scale, Lordship.
Yes.
If your Lordship may be allowed to refer to the release order, that will make the facts very clear, Lordship. Page 27 of the read petition. Lordship, I'm in WPC number 39, the first read petition, Lordship. WPC number 39 of 2020. I may be allowed to take your Lordship to page 27, Lordship. Page 27, Lordship. Lordship got it. Annexure 9, page 27, Lordship. May I read it, Lordship? This is order dated 2nd of July 2013. On completion of 35 years of continuous service in respect of Shri so-and-so, work charge sectional assistant in this establishment of the executive engineer, PWD R&B Tuensang, Central Division Tuensang is hereby released with effect from 30/6/2013. This shows that he was on work charge sectional assistant. He has completed 35 years of service. I was met to go empty-handed, Lordship. Now the decision rendered by the Honorable Apex Court is very clear, Lordship. It squarely covers my case. I'll be also relying on the 2 decisions rendered by this Honorable Court, Lordship.
When have you approached the department?
Lordship, if your Lordship may kindly turn to the next page, page 28. That is my representation, Lordship. It is dated 28/10/2019. 28/10/2019, Lordship. Page 28.
You were released in the year 2013.
Lordship.
And you filed a representation in the year 2019.
Lordship. Now, in my active service, I have approached on 2 occasions for regularization of my service, Lordship. And I've stated in my paragraph 21 of my read petition why there was delay in approaching the authority as well as this Honorable Court, Lordship. I've categorically stated that due to poverty and illiteracy, Lordship, I could not approach the authorities on time, Lordship. Page 20, paragraph 21 of my read petition, I've categorically stated, Lordship. Now the state has filed the affidavit. There are 2 specific contentions raised by the state respondents, Lordship. There's no policy for ex post facto regularization. That is the first contention. Second, there's a delay that was the contention, second contention raised by the state.
Where have you explained the delay? Let's see.
Lordship will find it page 13, 1-3, paragraph 21, Lordship. Paragraph 21. Married, Lordship. Page 13 of my
Page 1-3.
1-3 of my read petition, Lordship.
Page 1-3. Yes, para 21.
Yes, Lordship. Paragraph 21. Married, Lordship. That it is humbly stated that a petitioner could not approach this Honorable Court on time due to illiteracy and poverty, and as such, praised before this Honorable Court that a delay in filing the instant petition may be controlled in the interest of justice.
This does not satisfactorily explain your delay.
And that it is the only reason why, Lordship, there was delay in approaching this court, Lordship. Now, Lordship knows about
If this is the ground,
Lordship,
you could have never come before this court. If this is the ground,
Lordship,
illiteracy and poverty.
Lordship.
You were a person who was working on a scale pay. How can you claim yourself to be a poverty-stricken people?
Moreover, if I may be allowed to make my humble submission that he was also ignorant to
Ignorant of law is no excuse.
Lordship. Now, Dalsibai's case is very clear that state should not be made to
You cannot automatically rely on that Talsibai's case.
Lordship.
What was the fact in that case? Tell me.
Lordship, the
What
fact
was
is
it?
that-
He was an ad hoc appointee.
Lordship.
Yes, but what was the fact? What time he approached the court?
Those aspects were not discussed. However, Lordship, a specific mention has been made in this decision, Lordship. It is clearly stated that the state cannot be permitted to take the benefit of its own wrong.
Yes.
The state has utilized the service of the petitioner in this case, Lordship, for 30 years, and he was met to go empty-handed. That was the
That is one
observation
aspect.
made.
That is
Lordship.
one aspect.
Yes, Lordship.
What about your delay? That is another aspect.
Lordship.
The court has to balance.
Lordship. And during my active service, I have also approached the authorities on 2 occasions, Lordship. The records are also very clear, Lordship. If I may be allowed to place reliance on a decision.
Okay, we will hear you, but we are taking this, your para 21 seriously.
Lordship.
Okay. What are the other citations? What are your citations?
WPC number 105 of 2021, Lordship. This is the order passed by this Honorable Court, Lordship.
What is that Talsibai case?
Talsibai, Lordship. This is order dated 18/2/2022, Lordship. State of Gujarat and others versus Dalsibai, Lordship. This order is just one paragraph, Lordship. If I may allow to read it, Lordship. It is unfortunate that the state continued to attack the services of the respondent as an ad hoc for 30 years, and thereafter now to contend that as the services rendered by the respondent are ad hoc, he is not entitled to pensionary benefits. The state cannot be permitted to take the benefits of its own wrong, to take the services continuously for 30 years, thereafter to contend that an employee who has rendered 30 years continuous service shall be eligible for pension is nothing but unreasonable. As a welfare state, the state is as such ought not to have taken such a stand, Lordship. In the present case, the High Court has not committed any error in directing the state to pay pensionary benefits to the respondent who has retired after rendering more than 30 years service. Hence, the SLP stands dismissed. In this case, the petitioner, he served 30 years on ad hoc basis, Lordship, and he was meant to go empty-handed without any pensionary benefits. Direction was given to give such benefits to the petitioner, Lordship. The Lordship may kindly allow me to place reliance on the decision rendered by this Honorable Court, WPC number 105 of 2021, Lordship.
What is the ratio laid down in this case?
Lordship,
what is the ratio?
It has discussed about, it's a similar case, Lordship. The state has utilized his service for 35 years. He was meant to go empty-handed, Lordship. Similar with this present case, Lordship. It is a short order, Lordship, if I may be allowed to read the facts, Lordship.
I have read. Okay, cool. We'll hear you after lunch.
Lordship.
This is which one?
Before.
Twenty-five and 26. This is 25. Yes.
Lordship. If Lordship may kindly allow me to place reliance on the decision rendered by Reed.
Go to your facts first.
Lordship. Lordship may kindly turn to page 16. This is the initial appointment order, Lordship. This is an extract copy of the service book, Lordship, of the petitioner.
Where's the appointment order?
Lordship, a copy of the appointment order was not available at the time of filing this Reed petition, Lordship. However, we have enclosed the relevant page of the service book, Lordship. This shows that he was appointed on in the year 1978, Lordship. 1st July 1978, Lordship.
And who has certified this page? There is no certification.
Yes, Lordship. This is a part of the service book, Lordship. Subsequently, Lordship.
Without certification, how do we rely?
However, the appointment has not been disputed by the state respondents, Lordship. He was released after serving for 35 years of service, Lordship.
Where's the other order of appointment?
Lordship, the second, page 17, that Lordship will find it, the type copy, page 18, Lordship.
Hereby appointed, promoted.
Page 18. May I read it, Lordship? Subsequently, he was promoted, appointed as work judge, Mahuru, Lordship. And in the year 1986, he was reappointed as sectional assistant.
Wait. Let us go slow. First, take this court to properly to the facts, not the law.
Lordship.
Yes, after this promotion in the rate 85, what happens?
Next is Lordship, page number 19. Lordship.
Some order under his receiver is able to transfer and post it. Page 19 is
19 is the
Transfer.
appointment Lordship. He was reappointed again as work church sectional assistant Lordship.
So is ever appointed as work church sectional appointment.
This is dated 2nd April 1986 Lordship.
Sectional work church.
Sectional assistant work church Lordship. On work church basis.
Okay, thereafter?
Thereafter Lordship, he was transferred and posted under SDO, PWD Twensang.
Then?
Then Lordship, if your Lordship may kindly turn to page 22. During his active service, he has made a representation, Lordship.
This page 23 is the type copy?
Yes, Lordship. 23 is the type copy, Lordship. The petitioner's application was forwarded by the EE to the Chief Engineer, Lordship. And another application was submitted in the year 2012, Lordship. Lordship will find it page 26.
Yes.
Lordship, and finally, he was released from service, 27, page 27, on completion of 35 years length of service as work church sectional assistant.
Yes.
Now he was
Then?
released without any pension or pensioner benefits. Being agreed, Lordship, the petitioner has made a representation. Next, page 28, Lordship. Lordship, I admit the fact that this representation was submitted after a period of 6 years after he was released from service, Lordship. It was on 28/10 of 2019, Lordship. I have waited for the outcome for more than 5 years, 5 months, Lordship, after submitting this representation. However, no positive outcome, Lordship. Being aggrieved, I'm before this honorable court, Lordship, seeking for appropriate relief.
Are you also relying on 2015 notification?
Lordship, only after I was released from service, 2015 was introduced, Lordship.
Okay.
So I'm relying only on 2004 OM, Lordship. OM, Lordship will find at page 24. Lord.
Let's see this division bench,
Lordship.
WA 15K.
Yes, Lordship.
Yes, what is the operative portion?
Operative, Lordship, will find it last page.
Yes.
Last page. Page 36. Page 36, Lordship, the last page of my petition, Lordship.
This Justice Ujal Bhuyan and Manojit Bhuyan. No?
Lordship, yes, Lordship. This is an appeal preferred by the state, Lordship, which was subsequently dismissed.
Against this judgment of single bench which you have annexed.
No, Lordship, that is a different case,
Against
Lordship.
different-
Yes, Lordship.
Okay.
If 36,
This is
the relevant page is 36, the last page.
36.
Lordship. May I read it, Lordship? The second paragraph, after hearing,
Yes.
the learned counsel for the parties and on perusal of the materials on record, we are unable to accept the contentions advanced by the learned additional AG, Nagaland. State is a model employer and cannot act like a private employer. Being a model employer, it is bound by the constitutional philosophy as expressed by the apex court in a pattern of judgments, reference to which may be not be necessary at this stage. Learned single judge had given due consideration of various aspects of the matter, and thereafter had taken the view that after entering 30 years of uninterrupted service, the state cannot deny pensioner benefits to the respondent. It is already held that by the apex court that pension is not a bounty, but an entitlement, Lordship, this is important, of an employee. Only the quantum depending on the number of years of service rendered. Thus, we agree with the view taken by the learned single judge. It has also been brought to our notice that various orders have been passed by the state regularizing the services of similarly situated workchurch employees, thereby enabling them to withdraw pension. In the light of the above, we find no merit in the appeal, which is accordingly dismissed.
What was the judgment passed by the learned single judge? Any idea? Mr. Ma?
Lordship, as learned single judge has given a direction to...
Have you got a copy of that order?
No, Lordship, I don't have a copy, Lordship.
Can you
However,
trace it?
as per the discussion in this appeal, Lordship, learned single judge has given a direction to regularized for pension and pensioner benefits.
One day before.
Lordship.
One day before retirement?
Retirement, Lordship. And now the state has preferred an appeal against that single judgment, which was dismissed by this order, Lordship.
Okay. What about the judgment passed by the single bench? Let's see.
If I may be allowed to refer.
Yes, where is the operative portion of the order?
Page 34, Lordship. Page 34. The second page of the judgment, Lordship.
Page 34.
Yes, Lordship, of my read petition.
No. I mean the order pass, which is at page 29.
Okay. This is a different case, Lordship.
That's why.
Lordship.
What is the...
Okay, this is also similar with this present case. If I may be allowed to...
Yes, what is the operative portion?
Page 31, Lordship. Page 31.
Yes.
The last paragraph, Lordship.
After hearing.
Yes, Lordship.
Please read.
After hearing the learned counsel for the parties This court is of the considered opinion that the order dated 22/1/2014 passing WPC number 164K of 2013 covers the case of the present petitioner. Accordingly, this writ petition is disposed of with a direction to the state respondents to consider the case of the petitioner for regularization of service solely for the purpose of pensionary benefit. Such consideration should be completed within a period of 3 months from the date of receipt of a certified copy of this order. The outcome of such consideration shall also be intimated to the petitioner. Now it has discussed about WPC 164, Lordship, in this case. If I may be allowed to take your Lordship to WPC 164, the relevant portion,
Where
page
is that?
30, page 30, Lordship.
Page 30.
The previous page, Lordship.
Yes.
Page 30. May I read it from the top, Lordship?
Yes.
Mr. So-and-so, learned counsel for the petitioner, submits that this court in similar nature of cases has passed directions to the state respondents to consider the case of the petitioner for regularization of service and thereafter to pay pension benefits. He has referred to the case of Shrimati so-and-so, WPC number 164K of 2013, wherein by order dated 22/1/14, the state respondents were directed as under. Therefore, this proceeding is disposed of, requiring the state respondents to regularize the service of the petitioner and to grant her all pensioner benefits in accordance with the rules governing the service of the petitioner. The respondents' authorities are directed to complete the aforesaid process as early as possible, but in no case beyond 6 months from the date of receipt of a copy of this order. Pursuant to the order passed by this court in WPC 164K of 13, the state respondent had complied with the order dated 22/1/14 and has passed office order dated 4/9/14, which also reads as under. Order dated September 2014. In compliance of order dated 22/1/14 in WPC 164 of 13, Shrimati Rongsaninla versus State of Nagaland and others. The undersigned is pleased to observe Shrimati Rongsaninla work church sweeper under the establishment of EE PWD Housing Mokchong Division into regular cutter against grade 4 temporary post of sweeper and the pay ban of so-and-so, plus all other allowances as admissible under rules from time to time to similar posts in Nagaland with effect from 30/4/2012. The absorption of service into regular cutter is purely temporary and is liable to termination with 1 month's notice. The period of service rendered by the incumbent under work charge period shall be counted as qualifying service for pension benefit only. Other benefits like DA, ADA, arrears, leave engagement, and provision of MSCP scheme shall be admissible only after the actual date of regularization of service. In the interest of justice and public service, Shrimati so-and-so is posted under the establishment of EE so-and-so against the resultant vacancy. No appointment should be made against this post after the retirement of Shrimati so-and-so. So that was the observation and direction of the learned single bench lodge, single judge.
Correct.
Now I'm relying on both the single bench judgment and order as well as the division bench lordship. And it.
Then where is that order which was passed by the Honorable Supreme Court, the State of Gujarat's case?
Yes, State of Gujarat and others
Okay.
versus
Have
Dalsi
you,
Bai.
have you served a copy?
Yes, lordship, I have served a copy.
Okay.
If your lordship got it.
This is that Dalsi Bhai.
Yes, lordship. This order was passed on 18/2/2022, lordship. May I read it, lordship? It is unfortunate that the state continued to attack the services of the respondent as adhoc for 30 years and thereafter now to contend that as the services rendered by the respondent are adhoc, he is not entitled to pension or pensioner benefit. The state cannot be permitted to take the benefit of its own wrong, to take the services continuously for 30 years and thereafter to contend that an employee who has rendered 30 years continuous service shall be eligible for pension is nothing but unreasonable.
Shall
Be eligible for pension is nothing.
Shall
not be.
It
Shall
should
not be. Lordship.
Shall not.
Shall not be. My apologies, lordship. It's
Where,
not.
where is that word not?
Not this while printing, lordship. That word not has been printed out in this background, Lordship. Lordship, I have a different copy,
Okay.
Lordship, if I'm life law, Lordship. May I continue, Lordship?
Yes.
It is unfortunate that the state continued to attack the services of the respondent as ad hoc for 30 years and thereafter now to contend that as the services rendered by the respondent are ad hoc, he is not entitled to pensionary benefit. The state cannot be permitted to attack the benefit of its own wrong, to attack the services continuously for 30 years and thereafter to contend that an employee who has rendered 30 years continuous service shall not be eligible for pension is nothing but unreasonable. As a welfare state, the state as such ought not to have taken such a stand, Lordship. In the present case, the High Court has not committed any error in directing the state to pay pensionary benefits to the respondent who has retired after rendering more than 30 years service. Hence, the special leave petition stands dismissed.
Mr. Moore,
Lordship.
there are also other judgments of the
Lordship.
Honorable Supreme Court,
Lordship.
which has elaborately discussed this issue. Can you check up?
Lordship.
Can you check up this
Lordship.
similar issues?
Lordship.
Okay. Yes.
Lordship, therefore, my humble submission before this Honorable Court, relying on the decisions rendered by this Honorable Court as well as the Honorable Apex Court, Lordship, the state has utilized my service for 35 years, Lordship. I was made to go empty-handed, Lordship. I have also approached the authorities while I was in active service on 2 occasions, Lordship. And just because I have approached after retirement, after a lapse of 6 years, Lordship, the state is taking a stand that I have approached on a very late day, Lordship.
And rightly so.
Lordship.
Leaving aside your rights
Lordship.
to be regularized for pensionary benefits.
Lordship.
The state is also right when it says that actually you had belatedly approached this court. And I find that in your petition you have not made any grounds as to why.
Lordship.
There was as to why you had come before this court belatedly.
Lordship, I have stated my grounds were only limited to the extent that because of illiterate and poverty, Lordship. Illiterate being ignorant, Lordship. However, on the other flip side, Lordship, if I may be allowed to make a respectful submission that
yes,
the state has utilized my service, Lordship, for 35 long years, Lordship.
There is no doubt on that. What is your second case?
It's a similar case,
It's
Lordship.
a similar case for how many years you have rendered service?
I have served for 26 years and 9 months, Lordship.
We'll segregate. We'll segregate.
Lordship.
Okay?
Lordship.
Because there is a recent judgment by the Honorable Division Bench
Lordship.
disallowing such petitions.
Lordship.
You just see that judgment. It is
Lordship.
by Justice Devashish Borua and Justice Sato.
Lordship.
Okay?
Lordship.
So even if I intend to give you some relief,
Lordship.
I think that will act as a blockade.
Lordship, I agree, Lordship.
Okay, Miss Lucy, which is your case? Which is your case?
She's in
Don't
the
point
second-
at each other.
Next,
What is your case?
next one, Your Lordship.
You are fortunate you are escaping today. Yes, Miss Sapon. What is your case?
Lordship, I want to rely on my affidavit in paragraph number
No,
5.
first submit what is your case before relying on that. That will come afterwards. What is your case now? There is no doubt that the petitioner has served the government for 35 years. Correct? After utilizing his service for 35 years, one fine day you say that you are retired, you go empty-handed. Is it fair? Is it justified for a welfare state to actually do such actions, to undertake such, to involve in such actions?
No, Lordship.
And it is your own wrongdoing, see. It is the wrongdoing of the government. If they were appointed for any, like on work charge, then a work charge means actually the appointment is charged against the work. So as soon as the work is over, throw them out. But you have used their service for 35 years, imagine. You have utilized the life of this person for 35 years, and that too at the prime stage. And now, actually, on completion of 35 years, when that man is old, you say, no, you get out. You will have nothing from us. You go empty handed. Just imagine. I think this same yardstick should be adopted to some of the officers, so then they will know how it pinches. Just because the bargaining power of the petitioner is weak doesn't mean that you should take undue advantage. So what is your case? Submit. Let us go to the records afterwards. What is your case? What is it? Because you have filed counter. You have filed counter affidavit to the petition. That means you are actually opposing the case of the petitioner. So what is the ground?
Lordship, actually, Lordship, this matter was handled by my colleague, Lordship, and it was...
No, that will not be an excuse. No. Since when have you taken up this case? Don't misguide. I will actually see from the records the orders of this court. We are finishing the case today.
Last year, Lordship.
Yeah, last year.
Lordship.
And then that submission you are making today, I think that's unreasonable on your part. So make your submission.
Lordship, I've been going through this affidavit that has been filed, Lordship, and I found that I need one document, Lordship.
What document? What document? Tell me.
Lordship, since the petitioner fault, it has to be covered by 2004 OM, Lordship. So it has to be...
Forget 2004. Let us minus 2004. Let us say that the 2004 supports your case. Supports the case of the government. Assume. Let us assume. But there are other aspects to be considered. More important aspects to be considered than your 2004 notification. And even under 2004 notification, this petitioner has a right to be regularized. So 2004 notification now. So what is your submission? I will record. No more time. You make your submission. And this is 2020 case. I think for this, such cases should not be kept pending like this. You make your submission. Yes. Don't always come in a very casual manner. Don't come. I find that you government lawyers, most of you, always coming to the court in a very casual manner, just carrying the file. You don't do research, you don't read your files, you don't assist the court. That is what I find. And I can say this because as a government lawyer, we were acting quite opposite to you. So make your submission. At least we will have one disposal today. Yes, make your submission. No time.
If I may be allowed to rely on my affidavit, Lordship.
Okay. Where's the affidavit? Yes. Which para?
Para 5 and 7, Lordship.
Para 5 and 7.
Lordship.
Okay.
If I
Para
may
5.
read, Lordship.
Yes.
That with regard to the statements made in paragraph 5 of the writ petition, The deponent would like to state that the OEM dated search and Exterior 7 of the writ petition is a policy and scheme for regularization of work charge employees to be considered against clear sanction posts and on the basis of seniority cum merit. This means that the senior most work charge employee in the relevant category will be regularized subject to his or her fitness for the vacant post. There are thousands of work charge employees in the department and for which hundreds of work charge employees whose cases were similarly situated to that of the petitioners were also released from service without regularizing their services due to non-availability of vacancies in their division. Lordship.
You are fortunate that these people who were regularized after 35 years of service has not come before this court. Yes,
There are 7, Lordship.
yes, your para 5 doesn't make much sense. Let's go. Yes, para 7.
That with regard to the statements made in paragraph 8, the deponent would like to state that there is no obvious record of receiving the petitioner's representation dated 28/10/2019 by the department, whereas the petitioner was released from service via office order number such and such. Moreover, submission of any representation for regularization of his service after a gap of almost 6 years does not hold any substance and therefore not maintainable, Lordship.
Okay. We cannot take this ground that there were thousands of work charge employees, those who were released on similar grounds. No, we cannot take that. You should be thankful to those employees who did not approach this court. It is your own creation, madam. It is your own creation. This problem has been created by the state. We can't help it. But as a welfare state, you cannot treat your employees in such a way, in such a manner. Mr. Jamir, this is in WBC 39, okay? The learned counsel for the petitioner and MS Sopong Chang, the learned government advocate for the state respondents. Heard the parties at length. Judgment reserved. WPC 142/2019. Is segregated from WPC 39/2020. Okay, Mr. Lodge, who's going to read? Segregate this, okay.
Item number 35.
Supplementary. Oh, supplementary. Yes, Mo, what is this?
Lordship, the matter pertains to posthumous regularization, Lordship.
Posthumous again. How much years you have served? Whether the government has filed affidavit?
Yes, Your Lordship, I have already filed my counter.
Then Mr. LT, you are for?
No, Your Lordship. Lordship, actually, this matter was listed yesterday, Lordship, and certain informations were sought by this honorable court. As regard to Office Memorandum 2015.
Okay, Mr. LT, you be here. I think we will need your assistance. You were asked to produce that 2015
15 Office Memorandum.
Yes,
Lordship.
let us see. Now, what difference do you find, Mr. Moa?
Lordship, firstly, 2015 is exclusively for work church employees.
Work church and casual.
Casual, Lordship, yes, sir. Work church and casual, Lordship.
And this 2004 is for?
Only for work church employees, Lordship.
Only for work church.
Yes, Lordship.
So, doesn't make much of a difference. Where is that 2004? Where is that 2004?
Lordship, I have a copy of 2004.
No, in your writ petition?
It is also in my read petition as well as I'm furnishing a copy of the 2004.
2004. Anyhow, let us read it from your writ petition.
Lordship.
Which page? Just.
Yes, Lordship. Page 39, Lordship.
Page 39. Okay, just wait.
May I read it, Lordship?
Just wait. Let us first read 2017. Let us. Yes, please read. Please read. Regularization and service.
Lordship, 2004 OM, Lordship.
No, 17, 15.
15, Lordship.
Yes.
This is on the subject scheme for regularization and absorption of work church and casual employees and revision of pay and wages, Lordship.
Correct.
On due consideration of the report of work church and casual employees commission and in compliance with the judgment and order of Honorable High Court, the Governor of Nagaland is pleased to introduce the following schemes for regularization and absorption of work church and casual employees and revision of the pay and wages subject to conditions indicated hereunder. 1. Regularization and service. Roman 1, Lordship.
Yes.
All existing work church and casual employees of various departments who are enjoying scale pay and who have completed 30 years of or more continuous service as on 1/1/15, this is also important, Lordship, will be regularized by conversion of their post into regular ones, personal to them, and subject to fulfillment of conditions as indicated below.
Just wait. Huh?
Lordship.
Yes.
Lordship. A. The incumbent concerned and his or her service rendered as work church casual employee have been duly verified and found genuine by the district level verification committee constituted by the government. So this verification committee will see the genuineness of the employees.
Wait down.
B. Availability of service records, including appointment order, date of initial appointment, proof of length of service, age, etc. Lordship.
Yes.
C. Their suitability for continuation in service to be recommended by the heads of department concerned.
Yes.
D. The post occupied by them on regularization shall automatically stand abolished, as and when they vacate the post on retirement, resignation, death, etc. the strength of the work charge and casual employees under various departments shall stand reduced by equal number concurrently with the regularization of each such employees. No fresh appointment shall be made against this post.
Correct.
E. On regularization in service, the pay of the incumbent shall be fixed at the minimum of the corresponding pay band and grade pay as admissible under Rule 10 of the Nagaland Services ROP Rules 2010. F. The past service rendered as work charge casual employees shall be counted towards length of service for the purpose of Nagaland Retirement from Public Employment Act 2009 and as qualifying service for the purpose of pension. G.
Just with the past service.
Lordship, the
Re-
past service rendered as work charge casual employee shall be counted towards length of service for the purpose of Nagaland retirement from public
So,
employment.
Mr. Moore,
Lordship.
this speaks of the service after regularization.
Lordship.
Or what do you understand this?
Lordship, my humble understanding is, Lordship, for retirement, even their service on work charge or casual should be taken into consideration for retirement, Lordship.
No, that means after regularization.
Lordship, after
regularization.
Yes, Lordship, after
Except
regularization.
for seniority.
Yes, Lordship.
Okay, okay.
G. This scheme shall, however, not be applicable to the part-time casual employees, village cards, home cards, ICDS workers, other CSS paid employees whose services are guided by specific terms and conditions laid down by the government, and some other categories of contingency employee like personal peons, part-time sweepers, jockeys, seasonal workers, etc. H. The period of service rendered as work charge casual employees shall not be counted for purpose of MSCP. Roman 2. In respect of those work charge and casual employees in scale pay and who have completed or will complete 30 years of continuous service after 1/1/15, Lordship. Their cases for regularization will be taken up subsequently in 2 pages as on 1st July and 1st January every year. The procedures and terms and conditions will be the same as laid down in this office memorandum. Roman 3. The existing scheme for regularization of work charge employees against normal vacancy is being modified, and quota for work charge employees stands enhanced from 50% to 67% for the next 5 years with effect from 1/1/2015. This existing scheme will also be applicable for the casual employees appointed on full-time basis. Lordship, this existing scheme refers to 2004 OM, Lordship.
This existing scheme will also be. No. Existing scheme means this scheme of 2015. Because in 2004 memorandum,
Lordship.
you don't have actually casual workers.
Yes, Lordship. However, as far as 50%, Lordship, it has been enhanced to 67. And as far as 2004 OM is concerned, 50% is reserved for work charge employees, Lordship. So that enhancement was for a period of 5 years.
But the word this existing scheme would mean this 2015 scheme.
Lordship, apparently, Lordship.
Yes,
Yes.
read down, please. Okay,
2.
revision of pay of work charge.
Revision of pay, wages of work charge
Okay,
employees.
that is not relevant for us today.
Yes, Lordship.
Formula for fixation of pay, that is not relevant.
Yes, Lordship.
Besides, the reverse and so medical MSCP shall not be applicable to work charge and casual employees. MSCP, yes. Now, what is relevant is 1D. 1D.
Lordship.
Read this once again.
1A, Lordship.
1D.
D, Lordship.
Yes.
The post occupied by them on regularization shall automatically stand abolished as and when they vacate the post on retirement,
Yes.
resignation, death, etc. The strength of the work charge and casual employees under various departments shall stand reduced by equal number concurrently with the regularization of such employees.
Yes.
No fresh appointment shall be made against this post.
So, the intent of this 1/4
Lordship.
is to phase out
Exactly, Lordship.
work charge and casual employees.
Exactly, Lordship.
Now let us come to 2004.
Lordship.
Yes. Let
Page
us come-
39, Lordship.
Yes, yes,
This is OM dated 22nd September 2004, Lordship.
correct.
Subject policy and scheme for regularization of service of work church employees. There are large number of work church employees in various departments. Many of these employees have been serving continuously for many years. They have been representing to the government for regularization of their service. Some departments have been regularizing the service of work church employees from time to time against available vacancies. However, no transparent and rational policy and criteria is discernible in the process of regularization of service of work church employees. Therefore, in order to examine this issue of regularization of work church employees in various departments, the state government set up a committee under the chairmanship of Siri So-and-so, additional chief secretary. On the basis of the recommendations of the Committee for Regularization of Work Church Employees in the state, the government hereby adopts the policy and scheme for regularization of the service of work church employees serving under various departments of the state government. 1. Roman 1. Each department having work church employees should maintain a list of work church employees in various categories in order of their length of service. Roman 2. Regularization of work church employees will be done against available regular vacancies, Lordship.
Yes.
3. 50% of all regular vacancies of similar nature arising in a year will be reserved for regularization of work church employees, and the remaining 50% will be filled up as per normal rules of recruitment. 4. Work church employees will have the right to be considered first for regularization against 50% of all future vacancies of similar nature in the department for which they possess the requisite qualification. Such regularization will be considered on the basis of seniority cum merit. This means that a senior most work church employee in the relevant category will be regularized subject to his or her fitness for the vacant post. 5. In case, Lordship 5.
Yes.
In case no work church employee is found suitable for regularization in terms of the above clause 4, the department will obtain clearance of P&AR department before making any fresh appointment against the quota reserved for work church employees, explaining the circumstances for not being able to fill up the vacancy through regularization of work church employee. 6. No age bar would apply in cases for regularization if the work church employee is below the superannuation age. 7. Regularized work church employees will be entitled to count in full their continuous work church service towards pension benefits. 8. Those departments which have not approached the work church, Nagaland Work Church and Casual Employees Commission should do so immediately to get the optimum strength of work church employees fixed for their departments. They should take all possible measures, including pursuing VRS option vigorously to bring down that strength of work church employees to the level recommended by the Commission. 9. Adequate provision for for payment of work church employees should be made in the budget, and regular monthly payment of work church wages ensured. 10. All new work church appointments should be banned. Any person accepting work church service in the department would be doing so at his or own risk. Any new work church appointment should be treated as illegal and strict action taken against the appointing authority. In case of any unforeseen situation requiring new work church appointments, specific approval of the cabinet must be taken.
So this would mean that after this 2004 notification,
Lordship.
any fresh work church appointment
Lordship.
without the specific approval of the cabinet
Lordship. It's deemed to be illegal.
shall be deemed as illegal.
Lordship.
But read this 3.
Lordship.
Read this 3.
50% of all
Yes.
regular vacancies of similar nature arising in a year will be reserved for regularization of work church employees, and the remaining 50% will be filled up as per normal rules of recruitment. Lordship.
What do you understand by this?
Lordship, the vacancies arising in a year, 50% is reserved for regularization of those work church employees, existing employees, Lordship, and 50% to be appointed through regular selection process, Lordship. That is my humble understanding, Lordship.
when ban is imposed on appointment of work charge employees,
Lordship.
what is the necessity to provide such avenues again
Lordship.
for recruitment of fresh work charge employees?
Lordship, this recruitment, as far as my knowledge goes, Lordship, it is through the regular selection process, Lordship, and not work charge recruitment, Lordship. It is regular recruitment, Lordship.
No, but if you read 2015 notification,
Lordship.
regularization of work charge employees
Lordship.
was implemented to phase out
Exactly, Lordship.
fresh work charge appointees.
Lordship, exactly.
So is it not in conflict?
Lordship.
Let's now stick and read Roman 5.
Lordship. In case no work charge employee is found suitable for regularization, in terms of the above clause 4, the department will obtain clearance of PNR department before making any fresh appointment against the quota reserved for work charge employees, explaining the circumstances for not being able to fill up the vacancy through regularization of work charge employee.
So if no work charge employee is available for regularization,
Lordship.
then again fresh appointment
Lordship.
of work charge employees. What is all this, Mr. Sanktam? I think we need to do some exercise.
Yes,
The state, in some cases, the state have stated that 2004, this OM 2004 and 2007, 2015 has to be read in conjunction with one another.
Yes, sir.
But if we seriously read the provisions of 2015 and 2004, we find that there are contradictions. There are some provisions which is irreconcilable.
Your Lordship.
So when the two notifications cannot reconcile, how will the government say that actually 2004 notification and 2015 notification should be read side by side? That is the issue this court is having,
Yes,
that problem. What do we do?
Your Lordship, here, Office Memorandum, 22nd September 2004 says, seniority come merit.
No, that's okay. We are actually not discussing about seniority come merit. We are discussing about new appointments of work charge employees. When the intention of Office Memorandum 2015 is to phase out work charge employees, 2004 notification speaks about new appointment of work charge employees. And at the same time, it says that all work charge appointments shall be banned. And if there is a necessity, then such work charge appointments shall be made with the specific approval of the cabinet. It says. So I don't know, but I find that there is some contradictions.
My Lord.
Mr. Moore, assist the court.
Lordship.
I think this is the second case in which I am actually raising this issue.
Yes,
In the first also, we have raised this issue in a division bench.
Lordship.
And I vividly remember Mr. Moim Chan, the Lenasani government advocate.
Yes,
We had asked him to get instructions. And on the next day, he brought the instructions. He said 2004 has to be read in conjunction with 2015. But if we minutely read the contents of Office Memorandum 2014, 15 and 2004, we find that there are some differences which cannot be reconciled.
Your Lordship, I have consulted the PNAR.
Correct.
But stating that both the OEMs are in operation.
All the OMs are
In operation, Your Lordship.
in operation, but in conflict. How do we compromise that?
Yes, Your Lordship.
I think one day you will have to properly sit with all those officials.
Yes, Your Lordship.
Point by point, I think you will have to point out.
Yes, Your Lordship.
Because our actually the Guwahati High Court Kohima bench is filled with such cases. And therefore, unless we actually were able to properly know what is 2015, what is 2004, we will always be kept hanging like this.
The Lordship may allow me to place the decision rendered by division bench, Lordship.
Forget decision now.
Lordship.
We are on this. Let us first ascertain this.
This is about both the OIMs, Lordship. The division bench has given some observation, Lordship. In the appeal,
What is
Lordship.
that observation about these two ends?
In fact, this appeal, Lordship, it was heard before your Lordships on 2-3 occasions, Lordship. By this appeal, 2 appeals were taken up, Lordship. I'll check your Lordship only the last page, Lordship. A short paragraph, Lordship, paragraph 31, the last page of this.
I have read this. I have read this.
Lordship.
Yes. But which paragraph?
Paragraph 31, the last page of the judgment, Lordship. If your Lordship got it, 31, Lordship.
Yes.
We further make it clear that Office Memorandum dated 22/9/2004 would also continue to be applicable insofar as the same is not inconsistent with the Office Memorandum dated 17 March 2015.
This is the issue.
Lordship.
This is the issue coming up before this court.
Lordship.
It would have been better if the Honorable Division Bench would have decided all this.
Comprehensive discussion was also made, Lordship, in this judgment, Lordship, with regard to 2015 OM.
So if we read this judgment by the Honorable Division Bench, insofar as the same is not inconsistent with the Office Memorandum. So all those in 2004 Office Memorandum,
Lordship.
all those provisions,
Lordship.
which speaks about fresh recruitment,
Lordship.
should have to be done away with.
Lordship.
Correct?
Lordship.
If you have to read 2015, 2014, and if this judgment says that both this are applicable, and 2004 notification shall be applicable insofar as it is not inconsistent with 2015 Office Memorandum.
Lordship.
So that is why I'm raising this issue.
Exactly, Lord.
That 2015, the purpose of implementing 2000 OM 2015 is to phase out work charge employees.
Lordship.
Now 2004 speaks about fresh recruitment of work charge employees. How to reconcile this?
Lordship.
That is the issue I'm asking.
Lordship, if I may, Lordship,
Yes.
subject to correction.
Please.
Subject to correction, Lordship. 50% reserved for work church employees are those quota only for those existing work church employees. And the rest 50% is for those regular appointments. Not work church appointments, Lordship.
That is why, how can you directly appoint a regular work charge employee? How can you?
Lordship. Exactly.
How can you? That is not permissible under the law. Work charge means appointed for a very specific work.
Exactly, Lordship.
Charge against a work.
Lordship.
So you cannot actually directly appoint a work charge employee on a regular basis.
Lordship.
That is why the confusion.
Lordship.
Maybe we are not blaming the government because actually these are all policy decisions taken by the government. And then They may not be well conversant with the law. But when this comes before the court, then actually we are faced with this dilemma as to how to go about it.
Exactly.
How to squeeze out from these two notifications. So what to do, Mr. Sanctum? Your own creation,
Yes, sir.
your own baby. How to take care of your baby? Tell us.
To my understanding, Your Lordship, in Remand 3, 50% of regular vacancies
Yes.
of similar nature arising in a year will be reserved for regularization of work charge employees.
Correct. That is to that extent okay. That is in consonance with 2015 notification.
And the remaining 50% will be filled up as per normal rules of recruitment.
That is the issue.
That is what
50% shall be filled up as per the normal rules.
Yes, sir.
That means actually 50% of the post shall be recruited for regular appointment. Correct?
the actual meaning should have been for any other regular post, not for work charge. But nothing is mentioned about the work charge. That is how the confusion has
So
arisen. The real meaning is for regular appointment, not for work charge appointment.
that's what I'm saying. But if we actually look into this office memorandum,
Yes, sir.
the regular appointment means a regular work charge
Yes.
appointment. So that is the issue. There can be no regular work charge appointment. So what to do more with your case? That is where actually we are left hanging.
Lordship.
How long have you served?
19 years, Lordship.
And under which provision of 2004 your case fits?
Lordship, strict implementation of this interpretation of the OM, Lordship. It has to be considered against regular vacancy, Lordship. And
Let's see the 2004 notification,
yes, Lordship.
which provision supports your case. Let us see.
Page 39, Lordship.
39 years.
Roman 1, Lordship. If I
Yes.
may. Each department having work charge employees should maintain a list of work charge employees in various categories in order of the length of service. Second, regularization of work charge employees will be done against a regular vacancy,
Against available regular vacancies.
available regular vacancies, Lordship.
Yes.
3, 50% of all regular vacancies of similar nature arising in a year will be reserved for regularization of work charge employees.
Yes.
And the remaining 50% to be filled up as per the normal rules of recruitment. These are the 3 relevant provisions.
Yes. What is the criteria for filling up 50% of the regular vacancies, which is to be filled up by work charge employees?
It has to be on the basis of seniority come merit.
Where is your seniority?
Lordship, yes.
Where is your seniority?
Lordship. Lordship, for that information, Lordship, my humble prayer.
I think there is a seniority list
Yes,
maintained by the department.
Yes, Lordship. If I may be allowed to get the seniority position at the time when the petitioner's husband passed away, Lordship. And also whether at that relevant point of time any regular vacancies were available, and even as on today, Lordship.
As on today,
Lordship.
to consider your case,
Lordship.
for vacancy as on today.
As on today, Lordship. Yes, Lordship.
We have to see what was your seniority position then.
Yes, Lordship. I agree, Lordship.
That is why produce it.
Lordship, yeah.
Let's see whether you will have any case.
Lordship.
But I'm still very confused with these two notifications.
Yes, Lordship.
Mr. Sanctum,
Yes, Your Lordship.
I will not give any, I will not make any observation on this. Since the division bench has already stated that this OM 2004
Yes, Your Lordship.
should be read whenever there is no inconsistency with OM 2015.
Yes, Your
So I am not going into detail.
Much.
But why don't you one day call the officer, or why don't you take the pain
Yes, Your Lordship.
of going to the department with these two
Yes, Your
notifications?
Lordship. I'll do that.
And kindly note 2015, 17/5/2015. Okay.
Yes, Your Lordship.
You kindly take note of this 1D. 1D. 1D, na?
Yes, Your Lordship.
1D. Correct?
Yes,
You
Your
got it, na?
Yes, Your Lordship.
So it says that the last line, no fresh appointment shall be made against those posts.
Yes,
So once regularized, those posts has to be phased out.
yes, Your Lordship.
Correct?
Yes, Your Lordship.
Meaning thereby that actually no fresh appointment.
Yes, Your Lordship.
So this 2015 notification talks about no further appointments, phasing out the present work charge employees.
Yes.
But 2004, you actually 2004, whenever you discuss, you take this clause 3. Clause 3, 4. Clause 3, 4, 5. And 10. Clause 3, 4, 5, and 10.
Yes, Your Lordship.
This 2004 notification, it again speaks about fresh appointment.
Yes, Your Lordship.
So you tell the department, the government, when you have issued this notification 2015 to ban all work charge appointment.
Yes,
The 2004 still contains provision regarding
Yes.
fresh appointment.
Yes, Your
So whether actually 2004 notification is in conflict with 2015 notification. That answer I must get from you.
Yes, Your Lordship.
I will always remember that.
Yes, Your Lordship.
That I have actually given this homework to you.
Yes,
I am not a very forgetting, huh? I'm not a very forgetting
Yes, Your
person.
Lordship.
So whenever this question arises, it may not be your case. But I will have to actually request you
My Lord.
to answer this.
Yes, Your Lordship.
So immediately you take steps with the government
My Lord.
on this, okay?
Yes, Your Lordship.
I am not making any observation in view of the judgment passed by the division bench. Because I cannot go against this also. I cannot say that this is applicable, this is not applicable. But
Yes, Your
please come with
Yes, Your Lordship.
that information.
Yes, Your Lordship.
Third, Mr.
Wajamir.
Yes, Jamir, the learned counsel for the petitioner, and MS Lucy, the learned senior government advocate. I am not reflecting your presence, okay? But I have given you a homework.
Yes,
So don't forget, huh?
Yes, Your Lordship.
The learned government advocate for the state respondents. I will entrust both of you to get the seniority list.
Lordship.
The learned senior government advocate, you get it, huh? Okay? As well as the learned counsel for the petitioner shall make an endeavor to get the gradation list of the work charge employees in the, which department?
PWD Lordship.
In the PWD department on the next date fixed. Okay? When can we have it? We have it 2 weeks,
After 3 weeks, Lordship.
2 weeks,
Lordship.
2 weeks. You bring it, okay? You're listed on. We again listed on 19th,
Lordship.
okay?
Lordship.
Listed again on 19/6/2023. So, Mr. LT Sanctum,
My Lord.
please come properly instructed
Yes, Your Lordship.
on the homework which this court has given you.
My Lord.
Because that is an issue which we have to sort out.
Yes, Your Lordship.
Okay?
much.